All right, in court.
Mr. Mashiani, are the accused being fetched?
Yes, ma'am.
Accused may be seated. Mr. Mashiani.
Mr. Curtis, may I call the matter case number SS 026 of 2014 State versus Radovan Krejcir and 5 others. My lord, the matter is today on the roll for the sentencing proceedings. The appearances, my lord, we have for accused number 1, Mr. Radovan.
I think they'll announce themselves. Do you appear for the state?
As the court, sir, my lord.
Do you appear for the state?
Indeed, my lord.
Right.
For
Who
the
appears
state
for
is
accused
Mr.
one?
For number 1, we have Mr.
Well,
Radovan.
I'll ask them. Let them announce themselves.
As the court.
Yes, who appears for accused one?
May I please the court, my lord? I have been appearing on behalf of accused number 1 and 2. On behalf of accused number 2 as instructing attorney of Advocate van der Heever. As indicated to your lordship via communication through your Lordship's registrar, my mandate has been terminated to deal with a specific matter on sentence on behalf of the first accused. I therefore beg leave to withdraw as attorney of record on behalf of accused number 1. May I just also place on record that my last instruction from the first applicant was to request your Lordship that he not appear in court in handcuffs and chains. May it please the court.
Well, you don't act for it.
As the court pleases.
When did you notify my clerk that you were withdrawing?
Via email during the course of last week. I in fact withdrew in writing already last year, at the end of last year, but I have confirmed same during the course of
Yes,
last
so
week.
you've been off record since last year.
Yes, indeed, sir.
Yes. Is anyone appearing for accused 1?
I wonder if this might be an opportune moment to address your Lordship.
Yes, Mr. Karam.
As the court pleases. My Lord, in the course of last week, the state notified Legal Aid South Africa of the impending withdrawal of accused number 1's
The
counsel.
Legal Aid Board or Legal Centre?
Legal Aid South Africa.
Legal Aid South Africa.
Yes.
You are the people who
No.
supply counsel to accused who don't have a counsel.
That is so, my Lord. No reasons were furnished, and it was envisaged that the possibility may arise that it was due to lack of funding. Legal Aid various representatives, including myself, attended at a meeting on this past Friday, that is the 19th of February, at the prison and had a brief meeting with accused number 1. And it transpires that accused number 1 is neither needy nor indigent, and as such does not qualify for legal aid. And I would respectfully request that your Lordship place that on record.
Well, you've done it.
Thank you, my Lord.
Thank you. Who appears for accused 2?
May it please the court, my lord. I appear on behalf of accused number 2 together with Advocate Buthelezi and Advocate Simangi, as the court pleases.
Mr. Spinnerberg.
May it please the court, my lord, I still appear for accused 3 to 6.
3, 4, 5 and 6.
Correct.
Mr. Krejcir,
Yes, my lord.
what do you propose doing about legal counsel?
I beg your pardon?
What do you propose doing about having legal counsel represent you?
I don't need today legal counsel, my lord.
You
I will
don't need
represent
them?
myself.
You've been advised that you could have them. You had the legal aid services visit you. Your counsellors visited you, and you know that you can have legal counsel. You decline.
It's not declined, my lord. The legal aid visited me last week on Thursday, and they suggest, according to my information, Mr. Mashiani sent them to visit me. They visited me. They told me that they are here if I need them service. I couldn't lie to them. I still told them that I've got the money on the account of Mr. Nadis Crovier. So they said, in this case, unfortunately, we can't represent you because you are not qualified for us as a client for the legal aid. So these guys actually left. So I couldn't use their services. And regarding Mr. Nadis Crovier, that his mandate is terminated for several reasons, which I can...
Well, it doesn't matter. It's since last year. Is that right?
Sorry.
It's since last year.
Well, it's not since last year. It's I was transferred after in 9th of December to Kokstad prison. I couldn't have any consultation with my lawyers. I couldn't call them. So I had first opportunity to speak to Mr. Nardis Krejcir on 6th of February this year.
Yes, and you declined to have his services.
Well, there is a conflict of interest.
Well, I'm not
Yeah.
into. You declined to have him,
Yes.
and you declined to approach other lawyers to have them.
I approached other lawyers. I approached two different lawyers, which I believe some of them, they send you also notification. One of them is Mr. Cliff Alexander, but unfortunately they are not available for today.
And so what do you propose to do?
I propose to do, I would like to apply for the, or I would like to have the interpreter, my lord, and I want to launch the application for your recusal from my sentencing procedure.
Well, do it.
Well, I said I need a interpreter
Throughout
by the
this,
section 35 1K
Throughout this-
South African Constitution.
Mr. Krejcir, throughout this trial, which has been conducted in English, you have declined to have an interpreter. Is that not correct?
It's not correct because when I was testifying, my lord, I had an interpreter here. I can try. I can proceed now. I can try, my lord. I can. I'm ready, so we can start. Then, if it's some difficulties, I don't want to waste the court time, and I just want to state it that I'm really the last person who doesn't want to be sentenced or who wants to be sentenced not today. My present conditions are terrible. Since you last time on the appearance on the court.
Mr.
Speculating
Krejcir,
about my present
Mr.
condition.
Krejcir,
Yes,
I
sir.
don't want to hear about all those things. I want to hear about what's happening today. So you'll carry on.
I can.
You will carry on. Or
I
you
can
won't
carry on, and if I see that we have some difficulties because of my poor language, I can apply for the interpreter.
Good,
My lord.
good. Thank you.
Thank you.
Mr. Mashiani,
My lord,
is there a Czech interpreter?
no, my lord.
Well, you must make arrangements to get one in case we need it.
Indeed, my lord.
By no later than tomorrow.
I will do my best, my lord.
All right?
My lord, I just want to put one aspect very clear about the legal representation of accused number one. It is indeed so that Mr. Krejcir withdrew from the record late last year. However, my lord, I have since received a letter from Mr. Krejcir by email on the 27th of January 2016, where he indicated that he has been briefed once more to come on record to represent Mr. Krejcir for the sentencing proceedings. So it is not entirely correct that he withdrew already by last year.
Yes.
However, my lord, I must also clarify that I have received a telephone call, which was followed by an email from my lord's registrar last week Wednesday, to the effect that Mr. Krejcir is withdrawing once more from representing Mr. Krejcir. The reasons were not furnished, and as a result of that, my lord, I indeed made a phone call to the head of the legal aid board to see if they cannot assist Mr. Accused number one with legal representation. Hence, Mr. Advocate Kara placed on record that on Friday they went up to see accused number one. But as the development has it today, it would appear that accused number one is able to proceed and has chosen to proceed on his own. I think I'm therefore ready to proceed, man.
Yes.
As the court, please.
Thank you.
Thank you.
Yes, Mr. Krejcir, what do you want? Do you want to apply for my recusal?
My lord, the very last things related. Well, I don't believe that after a newspaper article, which was on Thursday, 17th of February, saying that I'm plotting to kill you, my lord, that you, my lord, are not biased, and even if you say that you are not, it's still my perception and perception of other people in general that you are biased, and justice must seem to be done. It's my perception to all the trial that you are the biased. I want to state it that I instructed my previous lawyers, who was Mr. Duplessis and Mrs. Annelien van der Heerwe, that I did ask to launch a recusal application for your recusal several times through all the court proceedings, but they didn't for some reason. And they told me, yes, but for me, as I said, for some unknown reason, they didn't launch this application. I terminated the mandate after that, after the conviction sentence. That was one of the main reasons. And I wish to call them in the box and that they can confirm what I'm saying. So I wish to call Mr. Duplessis and Mrs. van der Heerwe to answer if what I'm saying is correct or not. After your conviction judgment, I appointed new lawyer as Mr. Nadis Crovier. And my first instruction to him was to bring or launch application for your recusal as well from my sentencing procedure. But he refused as well. So I tried in person to bring this recusal application on the last appearance here for you, my lord, by myself, when I raised my hand in the court, at least for 10 minutes, and to draw your attention, but you completely ignored me, my lord. So I have been prejudiced, and I am able to show you why. So that's the reason why I'm asking for your recusal from my sentencing procedure. Obviously the main reason, because before I will start with all the facts, my application to you to recuse yourself from sentencing procedure is that you are biased, you are unfair, unobjective, dishonest, proven untruthful from record.
Just repeat: biased, unfair,
unobjective, dishonest, and proven on the record that you are untruthful.
And proven to be untruthful.
What is the other one?
Yeah.
I have
What are the
noticed,
facts,
my lord, that
Mr. Krejcir?
you always have
Mr.
to be-
Krejcir?
Yes, my lord.
What are the facts which underlie those conclusions?
It's facts from the transcript which I have with me. I would like to go through this transcript and go through all this unfairness or biasness from your side. My lord. Well, before we will go to this merits, I know you always asking for the authority. I brought some authority that I can bring the
Don't worry about the
recusal
authority
application.
now, Mr. Krejcir.
Sorry,
Don't worry
my
about
lord.
the authority now. Tell me why I'm biased. You've said because the newspaper published something, and you
No,
perceive.
that's the last things I said in the newspaper. It's not something. It was in the media last week. It was another article that I'm plotting to kill you.
Yes.
And I want to
That found that-
categorically state it is not a
Mr.
truth.
Krejcir,
Yes, my
has
lord.
that found that allegation? That's the reason why you sound biased.
Well, it's one of the reasons.
What's the other reason?
The other reason is that you always treated differently my counsel compared to the state counsel through the whole the procedure, whole the trial.
Yes.
Another reason is for you to putting not once your words to the state witness's mouth.
Put what? My words.
Your words, yes. Through the questioning of the state witnesses,
Yes.
you did put several times your words to the state witness's mouth.
Yes.
one of the also main reason for you to have always those secret confidential meetings with the security people and police, SAPS, who was whispering some stories and lies to you, to your ears without to disclose those fabricated sensational action stories to my counsel. For you to we started when we started on the 8th of the May 2014. This courtroom looked like a courtroom. Right now, as you look this courtroom, it looks like a circus related to the security. Because as I remember, we started with the 3 security people. After was 5. After I don't know what happened. But right now, when I turn here, this atmosphere in this court is I don't know what to say. I don't know what is the effects, why so many security people are here. Because as you said, there is the allegation that I wanted to kill you, but it's the same allegation that I wanted to escape. It's the same allegation that I had the gun in my cell and I smuggled this gun to my cell. It's the same allegation like every time before any court appearance in the newspaper, because the facts is that I never been charged for anything what this allegation said. Included all your security stories, what was brought to you, that I want to throw bottle on you and all this.
I don't recollect saying that.
Well, that was, my lord, I want to explain you know, when I went down one of the appearance, I released this information to the 2 TRT guys that I'm going to throw next time the bottle of the water on you.
Oh, you said that?
I said that because I wanted to know if this information will come to you.
Well,
It was only 2 TRT guys with me. The next appearance when I came here, you give the instruction that I mustn't take the bottle of the water with me to the appearance. This is what I received. So in my mind, I can see that this information clearly came to you without to disclose this information to my counsel, for example. Okay, there is a, sorry, for you, another reason for you to believe that I organized to kill you before when this court started. From the start, you explained or you mentioned the issue what happened to you on the way home. Then some bullet of chipstone break your window in the car. So I had this was the first moment when I applied for your recusal, and I with my advocate and with my lawyer. And I said, this judge can't continue in my case, obviously. If he believes that I want to kill him, then it's not how it's supposed to be. Because it's not true, obviously, and I don't know what happened with the story. It's on the record, but...
What's on the record?
It's on the record that actually you mentioned that... I will tell you exactly when we go
What's
to
on the record is that I said there was no evidence that you had shot me.
Yes, but you see that already that you mentioning my name...
I beg your pardon?
Already, my lord, that you mentioned my name in this case, in this... you know, in this situation, what happened to you, it's irregular. It's unfair. I mean, why will I try to kill you? First of all, and secondly, why did you mention only my name from 6 to accused?
I think there was some issue between you and the complaint that the newspapers were linking it to you.
You see, that's it's another allegation.
Would you just listen to me?
Yes.
And I said, as far as I'm concerned, it's not linked to you. Anyway, we don't need to debate all these things. Yes, what else?
I want to submit that you disclose information about my conviction to your close friends before your judgment.
Who?
It's your medical doctor.
My medical doctor.
Yes.
Who's
And
my
was
medical
the woman,
doctor?
she was here as
Who's my medical doctor?
Dr. Libos.
Dr. Libos.
Yes.
He's not my medical doctor.
Well, then, if I remember correctly, you mentioned that you know this person very well, and you
I do.
This,
I do know him very well.
okay. So.
And I've not seen him for that reason since I started with this case and became aware that he might be a witness.
I received the...
Until this date, I have not seen him.
Okay. Well, I received this information from my medical doctor who is working with him,
And who would that be?
sorry,
Who's your medical doctor?
Dr. Lichtenberg, Milan Lichtenberg.
Well, I don't know about all this, but I have not seen that man.
It might be allegation.
And
look,
I've not spoken to him until after your conviction.
Yeah. It's the same, you know, when it's.
Well, you want to know, I'm telling you.
I believe you. I am not.
Well, then that's the end of
I
that.
received this information. They sent even the letter and email to my family. That's what happened. So I'm mentioning you one of the reasons when we do this summary.
Yeah, what else?
Look, I believe that last time or previous time you interfere with my prison conditions without any facts. You just speculated that I am still awaiting trial or out-sentenced prisoner, but I should be treated like a convict, like a sentenced person.
Yes.
I believe that.
I said that in court.
Yes, it's in court.
Yes.
It's in court.
And I was told that the law is that you're not treated as that because the section provides that you're awaiting trial until you're sentenced. So that was dealt with.
Yes, but unfortunately you said that I can't have the same rights and privileges as an unsentenced person, as awaiting trial any longer. And that DCS must do something about it. And DCS did something about it.
No,
they sent me to Kokstad.
Well, they must do whatever they want. I don't decide that, and I was apparently wrong on the law. Yes. What next?
Another reason is that while my lawyer Duplessis was representing me, and it was I think 3 appearances ago, you had the comment to him that if he cannot explain me that I will be sentenced as soon as possible, that you're gonna explain me as you as a Lamont.
As a what?
As you as Lamont. You said to him that
well,
you.
It will be on the record.
Sorry?
It will be on the record.
Yeah, it will be on the record.
I don't
think it's.
Why does that mean I'm biased?
I don't think it's. I think it's irregular. It's first of all then.
Why is it irregular?
Because I had my lawyer here and who represented me, so it wasn't any reason to talk to me directly. And secondly, it was irregular because I am not the one who delay sentencing procedure.
Yes. What else?
Another comment was that I did nothing to proceed with the sentencing procedure related to this money issue, my lord.
What money issue?
There was the issue, if you recall last time, that Mr. Ramuhala, the very same investigating team, blocked this money.
Yes.
And I arranged money from my mother. She was those times on ICU in the hospital.
Yes, and what
You
happened
said
to
that
it?
I did nothing to bring this money and proceed the sentencing. So I just want to correct that I arranged this money through my mother. She was on the ICU hospital to be here in South Africa available on time, and for me to be able to pay my lawyers and counsel, senior counsel, which was confirmed from the Mr. Duplessis that he booked senior counsel Sita Kolbe SC, and she was willing to represent me. She even said that this time she's very busy with another long trial with Mr. Mashiane. I'm sure he's going to confirm as a prosecutor in this trial. But she was willing to prepare in the 2 Saturdays and 2 Sundays for me to be sentenced, and I was happy about this. It was arranged, it was confirmed, but when this money arrived, as usual, this money was sent as usual for past 2 years from the same person from my mother.
What's all this got to do with me, Mr. Krejcir?
It's got to do that you said that I did nothing to proceed, but I did everything to proceed, my lord. I did everything possible.
So what does that
I
mean?
even,
Mr. Krejcir,
Yes,
what
my
does
lord.
that mean I'm biased?
It means that you just speculate, my lord. I mean, you said you did nothing, accused number one, before
What
any
does it-
objective
Mr.
facts in
Krejcir,
front of you, my
What
lord.
does it mean I'm biased? That's what I'm asking you.
Yes, you are biased.
I'm biased, right? What else
Yes.
have you got to say?
I want to submit. I believe you are part of this conspiracy, which I was saying from the day one, my lord.
Which conspiracy?
Conspiracy against me and my family. It's a people that
When did I become part of this conspiracy, Mr. Krejcir?
I believe that you become part of this conspiracy since you start believing that I want to kill you when the chipstone break your front windscreen, for example.
Was it a chipstone? You seem to know more about it than I do. Is it?
No,
How do
you
you know
mentioned-
How do you know it's a chipstone?
You mentioned this as a one possibility, what could happen to
But
you.
you choose that possibility as a fact.
Well, I am saying because I know that I didn't do anything, so
No one's saying
and you
did
accuse
anything.
me. Sorry.
No one has said you've done anything, Mr. Krejcir.
Well,
Have I ever said you've done anything?
well, I had this impression, and you said on the record that I am. You actually discussed this matter only towards me, not to accuse 2, 3, or 4, or 5, or 6.
I think at that time there was some complaint about the newspapers or the television or just general in public that they were saying it was you. So I cleared it up that it was not you as far as I'm concerned.
Yes, that's correct.
So what's the problem with that? That's in your favor.
Well, it's in my favor maybe today, but it wasn't in my favor when it happened.
Thank you, Mr. Krejcir. What else have you got?
I believe that you stay in Bedford View, my lord.
How would you know that?
Well,
How would you know that?
I read this in the newspaper, like
You did. Which
Sorry?
one? Which newspaper?
I will come for the next appearance and bring this article.
Yes.
Yeah.
Is that a problem? Is it too close to where you used to live?
Yeah, it's very close. It's the same. It's the same district where I used to live.
And when did I start living there?
I beg your
When
pardon,
did I
sir?
start living there?
When?
Yes.
I started living there in
No, not
2008.
you. Me.
I beg your pardon.
Me.
You?
Yes.
What do you mean, you, my lord?
You say I live there. I'm saying, when did I live there?
Well, that's what I read in the newspaper. So
What's that got to do with your case?
It's got to do in my case that if it's true that you are in Bedford View and I am from Bedford View, and there was this issue in the media about the petition, people writing petition that
Do you
they
think I
believe
was
that I'm
living-
behind some bomb attack, which was some terrorist attack in the place in the Bedford View, where I used to go to this restaurant in the Money Point, and until today no investigation was done related to this matter, because it was attempt of my life, like a second matter, which was another attempt of my life with this red polo. Also, no investigation was done in this case from the state.
And what are you suggesting is my role in any of these things?
I'm just, it's not your role. I'm not saying that your role is related to this bomb attack or whatever. I'm just saying that if we live in the same place, because you are reading these newspapers, even though you said that you're not involved with the media, but I will prove to you on transcript that it was untruthful what you said, because one day you said to my advocate Van der Ierweg, Miss Van der Ierweg, did you see yesterday in the news, in the media, how did you wave your hands, for example? And in the 3 months later, you said you never watch the TV related to this case, you never read the articles related to this case, you're not involved with anything related to this case through the media. So I'm saying that one day you're saying, did you see yesterday, I saw you, go and look how you're waving your hands. But after you said, my lord, I never been involved in the, I never watched this
I do
TV.
try and sanitize myself from
For
the
example.
public expression.
So,
But I listen to the news. I hear this morning you said some things, or someone says you said some things, or someone's got an opinion about you.
but my
What
lord,
must I do?
you
Turn it
deny
off?
completely on the
Mr.
one.
Krejcir,
Yes, my lord.
must I turn it off? Can I be sanitized so completely from the public? I can't. I can only, as far as I'm able, disregard all this.
Well, look, my lord, I
Which are
complained
they?
several times that all these allegations from the media are just allegations and fantastical and sensational stories. More than 2 years, and there was hundreds of these allegations towards me, but none of these allegations I was charged or any action was taken. So it was just the fabricated allegations for newspaper sensational business.
And I'm treated that way.
I am not convinced, my lord.
Well, that's fine. I understand you where you stand. Yes, what else have you got to say?
I strongly believe, I want to submit that on the end of this case, when you give the conviction judgment, you didn't recognize, purposely you didn't recognize, incompetency from conspiracy. We went through the objective evidence, for example, with Mr. Ramuhala or one of my main investigating officer, or Mr. Gininda. These people are proven untruthful people on the record.
Well,
You
the
even give the
judgment's
strong
delivered.
judgment related to Mr. Ramuhala.
Mr. Krejcir,
Yes, my lord.
that judgment's delivered. You'll deal with it whenever you want to deal with it. If
What
you,
I'm saying,
you said I showed bias by giving the judgment in the way I did, is that your case?
no, I want to say that you are biased, that you deliberately didn't wanted to recognize that it's not incompetency from Mr. Ramuhala, but it's a conspiracy, because if it's incompetency, then he doesn't need to lie under oath. And if it's conspiracy, he's got something to hide.
Yes, thank you. What else?
You mentioned last time, my lord, on the record that it was this case where we're standing, it was very violent and I don't know this word now, but we will go through this. You actually say on the record that we all waiting for the long sentence imprisonment. So you believe we're supposed to have time to prepare, but I
Well,
stated.
that is the threat that faces you, long period of imprisonment. It's a serious threat that faces you.
Well,
And you need
because
to
I never
prepare.
been involved in this case, my lord. And
Yes.
I
What's
am,
the point that you're making?
my point is that you already said that this case is very unusual. This case is very violent. This case is very. I am looking for this word, but I can't remember.
Well,
this
I
word.
understand what you said.
Yes, and you said that I'm facing the long-term imprisonment.
You are. You're not going to face necessarily a 10 Rand fine.
No, I'm not
This is
saying,
not a loaf of bread case for 10 Rand.
my lord,
You're facing very serious charges.
which I never did it.
Well, that's a different thing.
I believe that you are biased because you already convict me. I believe that you will not convict me, first of all. So, and I never been involved in this case.
Yes.
So, that's why, I spent already more than 2 years in the custody for something which I never done. So, in these regards, if I am hearing that you saying is very violent, I am this dangerous criminal who will face the long-term imprisonment, then I am not happy about it. I believe that you are biased, you are
Well,
unobjective.
obviously you're unhappy about it. Anyone who gets convicted who keeps denying that he did something is unhappy.
Well, maybe somebody
I
is-
expect you to be unhappy, but does that mean I'm biased?
It
That's
means
the
that
point.
you are biased, that you convict me, even though I know that I never been involved in this case.
Yes, yes, what else have you got?
I want to say, my lord, that when I read the conviction judgment, me and the rest of the co-accused being convicted based on the testimony of Peter Musimang and complainant Lukele, basically. There is no one objective piece of evidence against me.
Well, you can deal with all of that in due course.
Okay, we will deal with all in due course.
Unless you say it has a bearing on me being biased, which
I
you
beg your
said
pardon, my lord?
unless you say it has a bearing on me being biased, which you say I am because I convicted you.
Yes, based on the testimony of the two people, without any objective piece of
Well,
evidence.
the judgment is there; it speaks for. I'm not going to debate the judgment with you.
That's we will go through it when I go through the judgment.
But Mr. Krejcir, while you look at that, may I just deal with something?
Yes, my lord.
Mr. Karam, do you have any further reason to be in court?
No, my lord.
Thank you very much for coming. Thank you for tendering the services of the legal assistance to the accused, and you may be excused from further attendance.
I use the opportunity to also
And you similarly, Mr. Fugitive, thank you. You may also. But are you not staying as the instructing attorney of the accused too?
my lord, I
the whole transcript. So I wish to be allowed to, if you can maybe give the court order that tomorrow I will be able to bring the transcript and we can go through it.
I don't propose going through the transcript page by page on your recusal application.
Well, that is the facts in the transcript, my lord, that I want to.
Well, you'll tell me what they are to the extent that you say they are there. You've told me many of them. What else do you have? And I'm aware of what's in the record. Yes, what else do you have, Mr. Krejcir?
My lord, that was only summary what I told you. Now I would like to go through the transcript, through the whatever I said to confirm exactly what was the words, what you used, and like I said, you used you put the words in the witness's mouth. I want to exactly explain you what I mean by that. So I really need this transcript to be available for me, that I can all this summary what I told you now to be proven word by word from you. I can do my homework. I did my homework, that I don't need to bring the 6,000 pages. I will bring only 100 pages, which we will be done in the 1 hour, for example. Then that will be end of my application.
You're applying for a postponement to produce further evidence.
Yes, my lord, because
Is that your application?
Yes, my lord.
Thank you. What do you have to say, Mr. Mashiani?
Well, I'm in the position to respond as regards the.
I'm asking you, what do
postponement.
you have to say about the application for postponement
As
to
I-
get the record? Do you think he needs to get the record, or you don't
No,
think
my
he
lord,
needs to
I
get the
don't need to get the record. I think
Well, the record
Mr.
speaks for itself.
Mr.
Right,
Krejcir
thank
has
you.
sufficiently made his case.
Thank you. Application for postponement refused. Yes, Mr. Krejcir.
That I will in this case, in this regards, if I cannot be allowed to bring the transcription, then I have nothing to say further.
Thank
My
you.
lord.
Do you have anything you wish to say about the refusal application, Mr. Mashiani?
Well, look, I do have
You may
something
sit,
to
Mr.
say.
Krejcir. Yes.
I just wonder if it's not opportune to give the co-accused a chance in case any of the co-accused want to pursue this kind of application, so that whenever I get to respond, I respond to all the applications that would have been brought.
I know. Do you wish to say anything, Mrs. van der Neef? Spanenberg. Thank you. Yes, Mr. Mashiane.
Thank you, my Lord. My Lord, it's my submission that the application for recusal should be dismissed. It would appear from Mr. Krejcir's application that he had gone through the various newspaper articles and read the allegations and turned those allegations into facts, which facts do not necessarily apply before this court. I therefore, my Lord, apply that the application be dismissed and we proceed with the sentencing.
Yes, Mr. Krejcir, do you have any reply?
My Lord, I would like to ask you, can I be unchained here in this courtroom?
It's a security issue.
It's only me who's got these chains.
Mr. Krejcir, it's a security issue which you must approach the relevant authority that chained you.
My Lord, I think you are the best relevant authority to,
No.
to take this decision. And it's showing you how biased you are if you don't allow me to be unchained.
Yes, Mr. Krejcir.
Yes,
Thank
my
you. Anything else you want to say? Is there anything you wish to say in reply?
I wish to say in reply that my application is correct, is based on the facts. Like Mr. Mashiane is saying, I used allegations from the newspapers. There was some, but I stated that from the media, but it's a fact on the record.
Thank you. Anything else?
That's all.
Thank you, Mr. In this matter, the first accused has brought an application for my recusal. The recusal application is based on the fact that there has been wide publicity concerning his threats to attack me and escape, and various other threats, including a previous attack upon me, which resulted in my windscreen being damaged, apparently by a chip, according to the newspapers. None of these matters evidence my bias. I'm not influenced by any of these matters, and in no way do I show any bias in relation to accused one arising out of the publication of his supposed conduct, which has not been established. There are various complaints made concerning my conduct during the course of the proceedings, and also in the fact that I found against accused one in the judgment which I made convicting him, in which I'm accused of making deliberate findings. At no time during the proceedings did the accused bring any application for recusal arising out of his perception that I was biased, and neither did any of his counsel, who represented him fully and completely, deem it appropriate that such applications be brought, and accordingly no such application was brought. I do not believe there is any merit in the fact that the accused currently contends that I'm biased relating to him, and that bias is reflected in the record. There is a submission made that I discussed certain matters concerning his conviction with one Libos. How this could get to the notice of the accused is beyond belief. It is true that Dr. Libos, who examined the accused and made findings relating to his medical condition, which findings were upheld incidentally, and became a consent issue. It is, however, equally true that I've not spoken to this doctor since I knew that he might be a witness, and until after the conviction. As to the security in this court, there are issues concerning the security. Originally, I made a ruling which I proposed implementing, and which was implemented, that the police who appeared in court should not carry long firearms. This resulted in, from time to time, interaction between the police and I, because it became apparent that they wished regarding the security issue for long firearms to be used in court. Currently, long firearms are used in court. This is a decision made by the police. It has nothing to do with me. And I dispute that there is any reason for there to be any perception of bias arising out of the fact that there are in court a large number of policemen who are well armed and who are here to protect not only the accused but the persons in this court. That includes the public, myself, and the various legal representatives and other court officials. There is no merit in the application brought by accused 1 for my recusal, and the application is accordingly dismissed. Right. Mr. Krejcir, what do you want to say about your sentence?
About my sentence, my
wait,
lord,
just wait, Mr. Mashiani wants to
Before
say.
we get there, my lord, I still have proven the previous convictions.
Yes, are there previous convictions?
Indeed, my lord. I must just indicate that it's only accused number 5 who has got the previous convictions.
Yes.
If the court can just bear with me for a minute. Accused number 1, there's no previous convictions.
So the only convictions you propose proving are against number 5?
Indeed, my lord.
Right. Mr. Spannenberg, are you aware of this?
I am about it.
Yes. Can they be put to the accused?
Sir, my lord.
Can they be put to the accused, or are they admitted?
My lord, I will put them to the accused. I'm just giving the court orderly the SAP 69 for the other accused. My lord, accused number 5 has got the following previous convictions. In 1998, 18th of December, he was convicted of 2 counts of theft. And on count number 1, he was fined 1,000 rand or 3 months imprisonment. On count number 2, he was sentenced to 6 months imprisonment, wholly suspended for a period of 5 years on condition accused is not convicted of theft committed during the period of suspension. The second one, Malota, was in 2007, May the 8th. He was convicted of contravention of Section 29 of read with subsection Regulation 85(4) of the Road Traffic Act for exceeding the speed limit. He was fined 3,000 rand or 30 days imprisonment. Those are the only previous convictions. Accused number 2.
Accused number 5, you mean?
Sorry, number 5, my lord.
My lord, these SAP 69s are not fully accepted as 2 counts of theft. It's only 1 count that they accused is accepting.
And does he accept the road traffic contravention?
Correct.
Right. So you accept that or not, Mr.
I
Mashiach?
do accept, my lord.
Right, so which count does he admit? The fine, the count he got a fine for, or the other one?
It's for the speed.
And then the previous one, he
It's
admits
not admitting the theft.
he's not admitting the one with the fine.
Correct.
The one with the fine. Not, yes, okay. Yes, Mr. Mashian, is that all?
That is all, my lord.
Accused one. Yes, what do you wish to say in amelioration of your sentence? You have an opportunity to tell me whatever you want to say.
Regarding the
You can
sentence
lead some evidence and you can yourself give evidence if you wish.
Regarding my sentence procedure, my lord, I wish to launch the application to have the legal representation because it's not only sentence, it's also leave to appeal.
No, it's not leave to appeal, it's sentence. You told me you didn't want legal representation.
No, I said I didn't want to launch the application for your recusal. I am now talking about the sentencing. I said I arranged my lawyer, my lord, the lawyer for the sentencing, which is Cliff Alexander, which he informed you is he is my lawyer, but he couldn't be present today. And I didn't have sufficient time to consult with him right now.
Yes.
I've got the rights. I believe I'm entitled to have the legal representation of my choice.
You are.
To choose and consult.
You are.
Which
But
I
you
choose
have
the
to-
lawyer for the sentence.
Mr. Krejcir,
Yes, my lord.
would you listen to me? You are entitled to have a lawyer, but you have to take steps to get him here at the right time. So
Well-
you've had plenty of time to arrange this.
I didn't have plenty time, my lawyer.
Why not? Why did
my
you not
lord.
have plenty of time?
I mentioned,
When did you appoint Alexander?
I appoint him on the
November, December, January, February?
it was January, my lord, if I'm not mistaken.
January.
I was in Kokstad. I couldn't have. I was declined to see my lawyers and speak to my
You
lawyers.
declined.
Prison. I mean the head of the prison.
They didn't let you see him.
They didn't let me see him. They didn't let
Ever?
me. He let me see him for 20 minutes once. After when I asked him to call him, they never allowed me to call him. I write maybe 50 of the complaints in the prison that I want to speak to my lawyer, and they never allowed me to speak to my lawyer. So I objectively couldn't prepare for this sentencing procedure.
And was Alexander supposed to come today?
I asked him to come today, and he referred to me that he is in the court, in the High Court, with the other matter.
So you knew when you appointed him he couldn't come here today?
It wasn't when I appointed him, because I only realized when I was brought back from Kokstad.
Mr.
When he came to
Krejcir.
see me in the Zonderwater, he explained me.
Mr. Krejcir,
Yes, my lord.
you knew all along today was the day, since last year.
No, it's not. About this day today, yes, I did.
Yes.
I did, yes.
So you knew it was today.
Yes, I'm saying that.
So when you appointed him, you had to find someone who could come today, am I right?
Well, I spoke to him only on 7 of February, when he came to visit me in Zonderwater. We also never been allowed in Zonderwater to consult in private.
When did you go back to Zonderwater? You say you were there on the 7th,
Yeah, on 6.
6th,
Yes,
till now.
yes, till now.
Yes.
So he's appointed as my lawyer. As I said, I also saw the criminologist. I arranged the criminologist, Mr. Zain. He came visit me in the Zonderwater. Unfortunately, he wasn't allowed to see the victim by this investigating officer, Mr. Amuhala. So he didn't meet the criminologist didn't meet the victim yet, even though he tried several times to arrange this meeting, but unfortunately Mr. Amuhala never arranged this meeting. I also have the one point that my diaries, which was related to whole case, my diaries was taken from me by the prison authorities.
When?
It was taken on 27 of September 2015. It was the diaries I was carrying every appearance here with my notes related to this case. We launched the High Court application related to these diaries. Unfortunately, I don't have copies. I don't have notes for 2 years when we went through this all this case. I want to say that unfortunately, because of this Kokstad, it's not my fault that I couldn't prepare. It's a fault, what I said already in the application for your recusal, that I believe that you are behind this transfer of mine. And secondly, that is a fault of the DCS, that the Department of Correctional Services, that they never allowed me to consult by the instruction from National Commissioner. They never allowed me to meet the lawyers, to speak to them for more than 2 months. And as a proof, I am saying I've got all these...
And you declined Krejcir, who came to work for you.
I beg your pardon, sir?
You declined to have Krejcir, who's a lawyer.
I declined Krejcir, yes, because after the last appearance here, my lord, as I mentioned to you, I raised my hand because I wasn't happy that he didn't bring this recusal application, and there is several different reasons which we are in conflict of interest. It's like a marriage, you know, the client and the lawyer relationship. When you get married, you are happy. When you go divorce, everything is changed, but you don't know when it's going to happen, the divorce. So this divorce happened between me and my lawyer, Nabis Krejcir, since I came from the Kokstad.
Yes.
And there is several different reasons. If you want me, that I can mention it.
Well, you declined to have him for whatever reason.
I beg your pardon?
You declined to have him. I mean, that's
Yes,
what I
yes.
understand. Right, what else?
So I brought some authority for the rights to have the legal representation, me as by my choice.
Yes, I told you, I accept that you have that right.
Yes,
But
and
it runs out of time. You don't get it forever. It's like you are allowed to address me. It does not mean that you can sit and address me for the whole year.
my lord, honestly,
It means that you have to take steps timelessly to obtain a lawyer, and then you can have it. And you've had, in my view, it seems to me you've had a lot of time to do this.
unfortunately not my lord, because as I said, I was brought in from the Kokstad on 6th of February. Today is
16 days
22nd.
ago. 16, it's more than 2 weeks ago.
Yes, I spoke to Mr. Cliff Alexander. He informed me we couldn't consult. That was the first problem in private. We couldn't prepare. I called on my own the criminologist. I find the criminologist for my case to be present. He is not ready with the record. This record is waiting for the approval from Mr. Ramuhala, investigating officer, to see the victim to finalize his criminologist report. From my side, from my family side, is done. Everything is only one point that we need to arrange this. He needs to arrange the consultation with the victim.
Thank you. What else?
Then I would like to ask you for the postponement for me to arrange my legal representative by my choice, which we know is Mr. Cliff Alexander, which I mentioned from the start, and I can read on the record just the authority for the postponement if it's necessary.
Well, I understand the authority that you're saying.
That's all, my lord.
Yes, thank you. Do you want to say anything?
Thank you.
Sven Jeffer?
I've got nothing to add at this point,
Thank
my
you.
lord. There was just one aspect. I don't know if there might have been a miscommunication about the use of the word decline. And as an officer of the court,
Decline.
he used the word decline as vis-a-vis Kokstad. And I don't know if there might have been a misunderstanding with the word. I think what Mr. Krejcir tried to convey to your lordship is that he was not allowed under any circumstances to consult during the period that he was in Kokstad. And he used the word decline in that regard.
How would you know this?
How would I know this?
Yes.
Because it's been reported in the newspapers.
No.
And I've
How
been-
would you know this as counsel?
how
That
would
he
I-
was refused. That he was refused access to his
Because
attorney.
I've been told that by another attorney, my lord. And as an
thank you.
officer of the court, I think I should be placed it on
Oh,
record.
so it's all hearsay. We don't know. Yes, Mr. Spanenberg,
I have nothing to add.
Mr. Mashiani.
Maybe as a starting point, I wish to indicate it is not correct that accused number one was refused access to consult at any stage. Now, my lord, he indicates that he was brought to Sonderwater on the 6th of February, which is correctly the position. But since the 6th of February, this marriage that he referred to was falling apart. But he doesn't do anything to get Mr. Alexander to come represent him here. He says, when I wanted Mr. Alexander to come to court today, he indicates to me he cannot make it as he's in another court. But other than that, no further steps are taken to have the accused legal representation here. I have addressed the court at length on the previous occasion that this has become a tendency where we're supposed to proceed with the sentencing, and all of a sudden there's accused number one with a reason not to proceed. And this clearly shows that it's a pattern that on the eve of the sentencing proceedings, accused number one would fire a legal representative and come to this court to say, I'm asking for another chance. My lord, one should also take into account that the accused was convicted already in August last year. This is now 6 months that he has been convicted. And on almost all the occasions, it was because the accused would fire a legal representative on the eve of the sentencing and then get a new one on board.
I'm not sure that's correct.
That is my submission, my lord. And,
Well, at one stage there were people who had to give reports who were not ready, for example.
yes. But on the subsequent occasions, my lord, it was because of the reason that the accused would fire a legal representative and get another one. Coming again, my lord, to the issue of legal representative, it has been clear that the accused today, by himself, launched an application for the court's recusal, and which was dismissed. It shows, my lord, that the accused is in a position to proceed with the sentencing. However, he just doesn't want to be to the sentencing proceedings to proceed. I therefore submit, my lord, with the greatest of respect, that the application as made by accused number one should be dismissed.
Thank you.
As a court, please.
Any reply?
My lord, I want to categorically state that what Mr. Mashian is saying, that I was allowed to consult with lawyers in Kokstad, is not true. I can provide as objective evidence my complaints, which I'm in possession with. It's more than 50 complaints that I'm complaining. I'm not allowed to call Mr. Cliff Alexander. I'm not allowed to call Mr. Nadis Krovia. I'm not allowed to consult. I want to state it that that's actually correct. And as I said, I apologized before that my poor English is not. So basically,
No, this is not a problem with the English.
when I said deny, it was I meant I wasn't allowed, because if you read it.
How would you count? How would the person who previously acted for you even know this?
Well, what I want to say, all the complaints, more than 50, is as a complaint. I am not allowed.
Inside knowledge through a friend of a friend of a friend, or I don't know what.
I don't know, my lord, but I want to say that all my complaints are in the title of the complaints is complaint because I'm not allowed to call my lawyer, or I'm not allowed to consult with my lawyer. It was that's all the right word.
At all.
At all.
You didn't see one lawyer while you were there?
I saw Mr. Alexander for 20 minutes. They chased him away.
Well, you did see him.
Yes, I did see him for 20 minutes. And also related to this lawyer, it's not patent that I'm changing the lawyers. It was the before it was the Mr. Duplessis and Advocate Van Eerden. And I explained that I terminated the mandate because of not bringing this application for your recusal and after the conviction sentencing. After I appointed Mr. Crovier, and he confirmed he's got the money eventually, finally, from this investigating team, which they purposely blocked that I couldn't proceed last time. If I am not mistaken, not other accused was ready to proceed because they still was missing some of the documents and reports. So it's not like Mr. Mashian is saying that I am trying to delay. I want to categorically state I want to be sentenced as soon as possible to be able to change my present condition, which they are inhuman and is psychological torture. I wish you to come there and check by yourself to see what I'm talking about.
Am I convicted?
No, just to see as, because last time you just speculated I've got the rights and privileges, but it's not true. So I wish, and of course I want to proceed with the appeal, so as soon as I'm sentenced I will be more than happy.
Yes.
The last issue is that Mr. Krejcir received the money, 250,000 as he mentioned last time, on his account. Finally from the curator or from, I think it was from curator. And I'm still waiting for Mr. Krejcir to transfer this money to Mr. Alexander, Cliff Alexander. So this money is the last issue.
Did I not recollect you saying previously during the trial that you had many millions?
Yes, my lord.
Of pounds, I think, of pounds.
No,
Is
I
it
didn't
of
say pounds.
or of
That's
rands?
also, I don't know.
Is it pounds or rands?
I said Czech crowns, I think.
Czech crowns?
Yes.
I don't know, how many Czech crowns are there in a rand?
Like, let's say 1 rand is 2 Czech crowns.
Yes, so many millions would be many millions of rand,
Yes, that's
which you
correct.
have in England, I think you said. Where did
No,
you
I
say?
didn't say. That's
Or
also
overseas?
some allegation
I
I
don't know.
heard.
Mr. Krejcir, I'm trying to find
Yes, my
out.
lord.
Where is it? Overseas?
It's overseas in Czech Republic,
In
yes.
Czech Republic?
Yes.
So
This
you-
is the part of the money what my mother sent it last time for this, for me
Yes.
to be properly represented.
Yeah, but you have access to many millions of...
Well, that's correct, but
Yes.
she sent it 656,000 for this case.
But you can get more.
It's with the Mr. Krejcir, so I instruct him to transfer this money to Mr. Cliff Alexander.
Yes, thank you.
Thank you.
During November 2015, today's date, namely the 22nd of February 2016, was made known to all of the accused. All of the accused were informed that on today's date, the matters concerning their sentencing would proceed. Accused 1 has known since that date that today was the day when he was obliged to produce whatever he wished to produce by way of evidence and to obtain such representation as he required. Subsequently, on 3rd December 2013, there was, as I recollect, an attempt at making a bail application pending the hearing of today. I'm not sure whether or not the accused was present at that hearing, or if he was even represented. The fact is that he knew as of November that today was the day. He claims that he appointed one Alexander to act as his attorney or counsel. Alexander is not present in court and to his knowledge was unavailable to be present in court today. He well knew that if he persisted in the appointment of Alexander, that Alexander would not be, as indeed he currently is not, present today. He consulted during early February, about 6th of February 2016, with one Radovan Krejcir, who seems to have thought that he might act for him, and who at one stage apparently did act for him, withdrew his mandate, and was told that he was no longer acting as of 6 February 2016. That is some 16 days ago. In my view, accused 1 has had ample opportunity to obtain legal representation. It is true that an accused person is entitled to be legally represented and properly represented at his hearing throughout, and that it is one of the constitutional rights which he has. It must, however, be recollected that while it is a right of the accused to be properly represented, it is equally the right of the administration of justice to proceed to the end of the trial. There comes a time when there will be no longer any postponements and when the issues which face the accused must be dealt with. Today is that day. The application for postponement is refused. No. Yes, Mr. Krejcir. What do you wish to say concerning your sentence?
I have nothing else to say. Thank you, my lord.
You are entitled to say, to inform me of your personal position by way of evidence or from where you are, or to produce witnesses which should be available.
Then I would like to subpoena the social worker from Zonderwater. And
Why is that person not here?
well,
Why have you not done it previously?
my lord, I am not a lawyer. Firstly, secondly, it's my first trial in my life.
Yes.
Thirdly, it's my first sentencing trial in my life.
Yes.
And I wish, I am, as you know, in the hospital section since day one from the arrest. I wish to also subpoena the medical nurse from the hospital
Why?
section
To say what?
to inform you about my medical conditions.
Can you not inform me about your medical condition?
I can't inform you. I need a psychiatrist, psychologist, and psychiatrist woman from
Why
the
have you not
prison.
taken steps to acquire such evidence?
I did spoke a lot. I had the first opportunity to speak to the psychiatrist and psychologist last week on Thursday. I did inquire them to if they are ready to come and testify in the court. They told me they will be able to go. They need just the subpoena to call them, and they will come with the evidence as psychologists, psychiatrists, and social worker.
You have known since the beginning in November that you needed witnesses. Why did you not take steps to arrange them?
I knew I was transferred to Kokstad, my lord. I wasn't allowed to call anybody, not only my lawyer. I didn't have any access to anybody. So when I came back on 6th, the first opportunity, I write on 7th of February the request to see the social worker, psychiatrist, and psychologist from the prison, and I was allowed to see them on last week on Thursday. So when I saw them as the first opportunity, I told them that, and they agree to come and bring the evidence in my sentencing procedure.
And did you tell your lawyer, Mr. Alexander, Mr. Krejcir, or the proposed lawyer who came to see you on Friday about these things?
You see, my lord, I was doing everything possible to have the lawyer here today, and as I'm saying, I want to be sentenced as soon as possible.
Well, it's
Also
disputed by the state, Mr. Krejcir. They say, no, you've
I
had...
beg your pardon, my lord?
The state says you've had access.
I didn't. And also, on my personal, I personally find a criminologist, call him there, consulted with him, so he's ready with all the report. And
Well, where is he? Why isn't he here?
Unfortunately, he is waiting for the approval from Mr. Ramuhala to see
Why
the
isn't he
victim.
here to say whatever he's got to say anyway?
He expects that this case will be postponed, that he can be able to obtain this evidence from victim.
Why would he expect that? You know there wasn't going to be a postponement, didn't you? Or not without some serious problem.
I can, if I will be allowed, I can call him, my lord, and tell him to come here.
By when?
Now or tomorrow. I wish
What else?
if we can. Also, these people from the Zonderwater prison are ready to come and testify. So if you allow me, or if you give the court order for them
I want
to
to
be
know
here.
what they're going to testify about, and I want to know what you have to say about your psychological or medical conditions which make it relevant, and I want to know from you the other personal factors which concern you, like how old you are you married, do you have sort of dependent children, what job do you do, what role did you play in society, all these things I would like you to tell me.
Well, I did tell this to
Well, you can tell me.
criminologists.
You can tell me. But you say you first, yes?
I said
Nothing.
that.
So you can tell me these things.
The criminologist obtained in his criminologist report also the information from my family.
Well, I'll hear it from you. You can tell me as well.
Well, I can't tell you, my lord, because I'm not a psychiatrist. And
No,
I'm
you
not
can tell me
I
the-
believe I was psychologically tortured for past 2 years. That's it, what I believe.
Mr. Krejcir, you can
Yes,
tell
my
me
lord.
the facts on which you rely, and I'll deal with them.
The facts,
Yes.
as a medical
How
facts,
old are
I'm
you?
not a medical doctor. my
How
lord.
old are you?
How old?
Yes,
I am 47 years old.
47 years old. And are you married?
Yes,
And how long have you been married?
for past 25 years.
And do you have children?
Yes, I do.
How many children?
I do. Is a one son, 23 years old, Dennis,
Yes.
and is another son, Damien, 6 years old.
And is your oldest son self-supporting?
I beg your pardon, I don't understand.
The oldest son, the 23-year-old, is he self-supporting?
What do you mean self-supporting?
Does he look after himself financially?
I don't know, my lord. I
You don't
think they've been deported from this country.
So you don't know? Do you know or you don't know?
I don't know.
And with whom does he live?
He's living with his wife.
He's married.
He's married.
And does he work?
He is studying, my lord.
And then who pays all his bills?
Well, it's my mother, I'm sure. It's
Out of these millions?
yes.
And your 6-year-old?
He is gonna start school next year.
And who does he live with?
He's living with the mother
And
and also with his brother and brother's wife.
and how does he cope financially?
I beg your pardon?
Who pays his bills, his expenses?
The little one.
Yes.
I'm sure that it's from these millions.
And where do they live? Where? Which country do they live in?
They live in Czech Republic.
And do you work?
Beg your pardon?
Did you work prior to coming to being incarcerated, to being put in jail?
No, my lord, I didn't work.
Not work. And
I
what?
stopped working in 2005.
Since 2005.
Yes.
And what did you do before 2005?
Well, I went to school after the high school, after the university. I had this degree of the economy, and in the meantime was the Velvet Revolution in our country, so I started my own company meantime, and I was part of this privatization in Czech Republic, where I had this opportunity to legally make this money. After I had a real estate agent, a company, printing company, and others. Since I felt that I don't need to work any longer, then I stopped working.
In 2005.
In 2005, yes.
And were you in the Republic in 2005?
Yes.
So did you work in the Republic at all, ever? Our Republic, South Africa.
No, I thought if I was in Czech Republic.
No, I mean South African Republic.
No, I came to South Africa Republic on 21st August, April 2007.
So you've never worked in this country?
No, I never worked in this country.
And what can you tell me about your medical condition?
That's why I asked to be here, the psychiatrist and the psychologist, because, as I said, I'm not a doctor.
No, but you know what affects you.
Well, I'm from the day one in the hospital, from the day of the arrest, which was 22nd of November 2013.
Since your arrest in where?
I was arrested in Bedford View.
No. Since your arrest, you said you were in the hospital. It was in the hospital
I was
section.
placed in the hospital section in Koshimampuru, Pretoria prison. I stayed there for 15 months in hospital section.
And why were you put there?
Well, the main reason why I was put there was the urgent application what my lawyer brought because of this torturing of Mr. Ramuhala when he arrested me. After this medical report of the doctors, they said that I've got some several medical problems, but I can't specify them. And after that, when I stay in the hospital, they discovered this mania depression illness, which I'm on chronic medication for past 10 years.
The past 10 years?
Yes, my lord.
But you say they discovered it?
Discovered
You
it there.
became aware of it?
Yeah, they wasn't aware of it. I said, what I understand, I was placed in this hospital section because of this High Court order, and that was related only for the injuries May I be allowed to have the interpreter, my lord? Because of this medical terminology, it's really difficult for me and I can't continue with this.
Well, what is the word that you're looking for?
Well, that I can tell you in Czech language.
Yes.
So it's já bych potřeboval, abys, yeah, well, it's not going to tell you anything.
You say it was some kind of depression.
No, that's not relating to, it was some mania, I don't know exactly, but it's not why I need an interpreter now. I want to explain all my feelings and all my stages when I went through since I was arrested. And it's some medical terminology which I need to be able to explain to you.
Yes. It became apparent during the course of your trial that you were diabetic, according to you.
No, it was also another allegation, my lord.
Was that untrue?
It's not true. It was the main problem I had also with high blood pressure. I'm the chronic patient for high blood pressure.
Yes.
I had previously the bladder cancer. And related to this medical issue, I really wish to have the opportunity to continue maybe tomorrow with the interpreter, please, my lord.
What else do you have to tell me about your family relationship or your situation in society, which you believe I should take into account in punishing you?
Well, it's a lot of things which I spoke to this criminologist for maybe 12 hours, and he made this report, all these reports. So, if I am allowed to,
he was with you for 12 hours.
I beg your pardon.
He was with you for 12 hours.
Yes, my lord.
Was that at the prison?
Yeah, it was at the prison. But it was on several occasions, not like once.
Several occasions. What,
Yes.
like an hour at a time?
Yeah, like 3 hours or 2 hours, and
So maybe 5 or 6 times.
maybe 4 times. Yeah.
4 times.
I must check properly.
No, roughly.
Yeah, I can bring you exact date and times.
About 4 times. Is this in February?
Yes, it was the last opportunity I have to speak to him was on Friday, my lord, 2 days ago, when he informed me that he severally tried to contact Mr. Ramuhala and make the arrangement. He said apparently that he will come back to him, but with this arrangement to see the victim, maybe it's arranged already today.
I beg your pardon?
Maybe it's arranged already today, I don't know, because I didn't have opportunity to speak to this criminologist. So on Friday, when I saw him last time, he informed me that he did several attempts with Mr. Ramuhala, but he's ignoring him for some reason.
Yeah.
But from my, as I said, from all these details, as also medical details is in this report. So I believe that this sentencing procedure is for 4 days. I might be able to bring tomorrow whatever he's got ready and present on my behalf, or he can present even without the victim statement or victim result of the consultation. And I might try to also convince this psychiatrists and psychologists to be here as well on my behalf.
Thank you. Mr.
Thank you.
Mr. Mashiani. So I have before me
Sorry, my lord.
I have before me a request to stand the matter until tomorrow for witnesses and to stand the matter tomorrow for the interpreter. So what do you say about for witnesses and what do you say about for the interpreter?
I've got no objection.
No objection to it
No
standing.
objection to the
Do you have any objection to it
I've got
standing?
no objection.
It means that you'll be interposing. Do you have any objection to interposing? It means I'll require you to carry on while the other matter stands down, Ms. van den Heever.
My lord, I do have a problem with that. I've also been handed
Well,
something.
then that has a serious impact on whether I allow it or not.
Yeah.
So what's your prejudice if I stand it down and require you to carry on immediately?
My lord, may I at this stage ask for a very brief adjournment? It's for a personal reason too, and I need to hand something over.
No, I
5
need
minutes.
to deal with these issues, Ms. van den Heever. We
Yes, I
can't
will
just...
Then I will deal with it,
adjourn.
my lord. I do not believe there's any prejudice to anybody if I ask that the matter stand down for a few minutes. We have gone past the tea time.
Yes, we've gone past the tea time because I'm trying to finish this matter.
Yes, I do understand that, my lord.
Right.
I again bring an application to the court that the matter stand down for a short while.
How much is a short while?
10 minutes.
Spannenberg?
I'm very prepared to
Yeah, so you can be interposed. Right. So we'll take a 5-minute tea adjournment and then we'll decide whether we're going to carry on with you, Ms. van den Heever, or with Mr. Spannenberg. Court adjourns for 5 minutes. The accused are to go down. accused may be seated. Mr. Mashiani, I see you standing.
Yes, my lord. My lord,
Sorry, what did you hand the accused now, Mr. Khruia?
Pen.
Sorry.
I asked the security
Yeah, sorry, I just see things changing. I see you moving around with a bag in court coming from the cells and handing things forwards and backwards.
To give to the criminologist.
my lord, with leave of the court, may I revert to the situation of accused number 1? The court will recall that on the previous occasion, it was indicated before this court that amongst the reasons that accused number 1 sought for postponement was to subpoena a nursing sister from the correctional service. I've just been informed that indeed the subpoena was issued and the nursing sister is here to give evidence. So we can proceed to deal with that part.
Yes.
And then the other portions we can deal with at the later stage
Yes.
as the court.
Mr. Krejcir, apparently one of the witnesses which you said you wanted to have is here. Right, so do you want to call her?
Yes, please.
Right, where is she?
Miss Capella, outside.
is correct, but normally all the nurses are able to see you if there's a problem. Consult when you want to consult. All the nurses will attend to you.
Yes, but what I want to say that all the nurses are not always on the duty. So sometimes you are on the duty, sometimes it's the other nurses on the duty. Is it correct?
Correct.
How many times did I call you personally, or you've been present personally, when I complained after the lockup or during the day about panic attack, what I had?
I was never called to attend to you for a panic attack. I was only called as a standby for that. But when we closed, was not allowed to. But when we closed, I was never called to attend to you for that.
So, if I understand correctly, you said you never been present since when I complained about the panic attack.
Aku bisa hantle o chono wena also ke ele teng nna ha ne ke tletleba kapa ke complain ka pele ka tech o botsisitse gore a ke ha so bitse na ka ka ao ha so bitse only just then it was locked already and then we are on standby and it's a kind of you asked the question if you never reported to me, called me direct. I told you that it was only during the standby. It was after the lockup.
Exactly. How many times it happened after the lockup that you've been present, that I pressed the panic button or call somebody to help me with the panic attack? How many times happened to you directly?
Ke makgetlo a makae mo wena o kileng wa tla o ba lebaka la hore nna ke ile ka pressa panic button. It was only once.
Do you have any knowledge that the other nurses came to see me after the lockup several times, or you don't know?
Na o na le tsebo ya hore dinase tse ding di tle tsa tla o nna ka mora ha lockup di tla ka lebaka le la ka ba haufi. I do, because every morning we give each other a report as to who was called for after the lockup during the lockup as to who was called.
You know, already you are not in possession of my medical file, so you can't say which exactly date and night I was held by you guys as nurses on standby or during the day. But if you say that you are aware that I called the other nurses, do you have any idea how many times happened since I was transported to Zonderwater prison?
I won't be able to say because I do not have the file with me.
If I ask you, was it there more than 10 times, for example?
No, I won't be able to say. I cannot give an estimation as to how many times.
Sister, do you know on which chronic medication I am every day on?
Medication it's a psychiatric medication.
Like, can you say which medication?
That I cannot say now, the says.
Why?
I was not prepared when I came to court today to give evidence on that. But the medication that you were given is a psychiatric medication. And And when I was subpoenaed, I was never told as to the reasons for the subpoena.
Correct. You say it's just where is your subpoena, sister?
Was the question where?
Yeah, this subpoena.
I do not know. I would.
My lord, I left the subpoena for the sister, I think downstairs, because we're not allowed to bring any stuff here. May I be able to have the subpoena?
Well, what do you say it says?
I beg your pardon?
What do you say it says?
The subpoena.
Yes.
Well, that's what I want
Well,
to.
it's your subpoena. You've read it. You've got it.
Well, that was the subpoena on behalf of me, sent it by my lawyer.
Which lawyer sent it?
I believe it was Mr. Nardis Crovier.
When did he send it?
I don't know exactly. That's why I want to have it and see it. But we can continue.
Yes, continue.
Yeah,
What condition was the accused being treated for?
When he came to the hospital, he was from Oshimampuru Central, and at that time he was already taking the psychiatric medication.
Is it any other medication than psychiatric that you know that I am every day using?
Only psychiatric medication aim with when it's around Yes, I know that there is the kind of medication which you are given for 7 days.
No,
What do you say it's called, Mr. Krejcir?
it's the medication. What
Yes.
it's called? It's if I can remind you, okay, I'm on Zanor as a psychiatric medication. Is it correct?
Correct.
It's I think 1 milligram a day.
Well, it doesn't matter what it is,
Okay.
but you get treatment.
Is it fluoxetine,
Yes, I know.
Ativan?
I do.
It's Dormicum,
Domicam, yes.
as every day as chronic medication. Is it correct?
That is correct.
For
you know
all-
that too.
For all the time I'm in Zonderwater.
Correct.
Plus is a painkillers, is a Tramacet and Gym Pain, 6 and 6 tablets a day, so
What
12
is it?
tablets a day.
What kind of medication? Tramacet.
Tramacet
Tramacet,
and Gen Pain,
also Gen Pain.
6 and 6 tablets a day,
Mm.
3 times 2.
Yes. There are other tablets that we normally give to you when you have complaints that you are given in between the medication that you have affected.
That's correct. There are other tablets, but I'm saying now this Tramacet and the Gem Pain is like a chronically. I am taking them on daily basis for a long period of time. The Gen Pain and the Tramacet are pills that you brought with to the hospital. You brought these pills with you from Oshimampuru. That's correct. It's all the pills I brought it from Koshimampuru. Is it correct, sir, sister?
In the pills that offer Oshimampuru. When you say all the pills that you take, you mean the psychiatric pills as well?
Yes, that's the Zanor, Fluoxetine, Ativan, and this Gem Pain and Tramacet. You guys supply me only in Zonderwater with the Dormicum as a new medication.
And when we come with the psychiatrist and the other medication, psychiatrist too, psychiatrist
The Domicam medication was prescribed by the doctor. a psychiatrist, and the other course that you were taking, we had to take you to see the doctor, the psychiatrist. It was for re-prescription that we took you to the psychiatrist.
You mentioned the psychiatrist doctor. Is it related to Dr. Dikobe?
Psychiatrist doctor, correct?
Do you know that I met this Dr. Dikobe several times since I am in Zonderwater prison?
Bana wa tseba hore se di kopane le doctor o makgetlo a mangata ho fela nako e fetileng ya yona. That is correct, because we took you to the psychiatrist so that when your pills are finished, you get the re-prescription.
Is it correct that in my medical file is the psychiatrist report about my conditions, medical health conditions?
That is correct.
But you don't have it with you, right? Sorry, my lord, can I maybe ask Mr. Mashiani to supply me with this subpoena, if he is in possession with?
I am in possession of that of this document.
What's the date on that subpoena?
It's 3rd of February 2016.
I beg your pardon?
If I'm not mistaken.
Sorry, what do you want to say, Mr. Schroeven? I see you making gestures.
My apologies, my lord. I issued it. It's a subpoena ducis tecum. It was handed to the sheriff last year. The prison authorities refused to accept service thereof, and it was then served by hand. It all appears from the document. But it is a subpoena ducis tecum, calling upon the witness to present a medical file at court.
Does she have control of it? I don't know, but these are other things. Yes, so ask her what you want to ask her, please, Mr. Krejcir.
The subpoena was refused by your sister.
Does it make any difference where we are today?
Well, what I want to say, my lord, that this subpoena was issued
Mr.
on behalf.
You'll do whatever submissions you want to make. Ask the witness the questions and fact to elicit the facts you want to be presented to me.
Do you remember I have also several meetings with a psychologist from the Zonderwater prison, Mrs. Dreyer.
Yes.
There is also the medical report in the file from Mrs. Dreyer.
Are you aware of its contents, Mr. Krejcir? Put it to her if you know. Someone's got a cell phone now. If you know what's inside there and you want to put it to her.
Well, yeah, okay.
You must know what's inside there, presumably you've seen it.
Yes, I
So then put it to the witness.
Sister, can you explain from your side, are you able to explain my psychological or psychiatrical condition, health condition?
Do you know what's wrong with Mr. Krejcir?
No, all I know is that you consulted with a psychiatrist and a psychologist. It was said that you have depression.
So, because you don't have medical file with you and you don't, there is no as your qualification, you are not psychiatrist. I didn't consult with you, so
She
you are not
agrees
able.
with you on all of that, Mr.
So
Krejcir.
you're not able to
Put to
explain.
her what your problem is. What do you say is wrong with you?
Yes, I
Then
asked her.
put to her. I say I've got this problem that's being treated.
Well, I think, my lord, that it's.
Or you can't put it.
I can't put it.
Well,
but,
then put it.
My problem is the interpreter.
Well, we'll try and deal with it.
Yes.
You've heard she
then,
says you've got depression.
Are you able, sister, to comment anything about my depression problems?
Na wena o le mo ba go ka kgona go hlalosa ka depression e ka go bona depression.
Psychiatrists and psychologists, they want to be experts for addiction.
Yes, and I believe that the psychologist and the psychiatrist will be in a good position to explain that.
That's all.
If you choose to tell us what you think might be wrong with you or what the doctors say is wrong with you, you might find the state is prepared to admit it, Mr. Krejcir.
For this time, I need, my lord, the interpreter and subpoena the psychiatrist and psychologist, my lord.
What do you say is wrong with you that needs treatment?
Well, that's my problem. I am not a doctor, and I cannot express myself in English.
These people speak to you, so then you will, Mr. Mashiane, can you arrange the interpreter at least telephonically for this accused?
Well, look, I did make attempts during the short interval. I couldn't get hold of Ms. Mchochoko. I'll try again.
So you
whenever
say,
opportunity arises.
I don't want this witness to come back.
I don't. I think we are done with this witness, my lord.
Thank you. Has anyone else got anything they want to ask this witness?
No
Mr.
questions.
Nipper? No, Mr. Mashiane?
None.
No, thank you. You may be excused. Right, what else do you want to say, Mr. Krejcir? I wanted to ask you something about the crime. One of the things that I have to deal with in this case is what impact this crime has upon the sentencing. So I'd like some comment from you about what you say the impact of the nature and extent of the crime has upon sentence. So you were convicted of attempting to deal in 25 kilograms, is that right? You recall that? Do you recall that?
No, I don't.
Well,
I was
enough-
convicted of.
Attempting to deal in 25 kilograms of drugs. Do you remember that?
Yes.
So now I'd like to know from you, how many people would be affected by 25 kilograms of drugs?
I have no
Do
idea.
you know how much a person takes at a time? Would they take
No,
a
I'm not
gram?
in drug business and I'm not drug addict.
You
so
don't know this.
I don't know this.
You don't know if they took a gram, let's say.
No, I don't know, my lord.
Let's say they took a gram, would that be 25,000 people that would be affected by your attempt to deal in this drug?
Well,
Because there are 25,000 grams in 25 kilograms. I'm just trying to do the sum. You say you don't know about these things.
no, I don't know anything about
Thank
these
you.
things.
Right, so we'll have to stand you down until we hear where the interpreter is.
Is it now the right time that I must ask this court to issue the court order, my lord?
What order?
Because I said I want to continue tomorrow as soon as possible. I need to call this guy as a criminologist.
Well, he's your witness. Get him. Why do I need to order him?
Now,
You
what
say
is
that
my
you've
problem,
got
my
it.
lord? When I go back to prison, I'm not going to be allowed to have the access to the phone. And I would like you, if you can give the court order that I will be allowed to call these people to...
No, I'm not giving court orders to call your witnesses. You must arrange with them to come.
But how, my lord?
Well, you can do whatever you want to do.
You see,
It's
I
not
don't
my
have
problem.
access for my phone here.
Mr. Krejcir,
Yes, my lord?
I'm not your lawyer. I'm not here to advise you. I'm here to deal with the problems which face me. You say one of those problems is that you can't phone. I'm sure that an arrangement can be made for you to make a phone call to him.
I don't think so.
Well-
Because that happened previously, and when I came back from the court, I applied for this, and
We'll
I
hear
wasn't
about
allowed.
it. Try, Mr. Krejcir. Do your best.
Well, I will try, yes.
Thank you.
So, also I want to say, I wish to subpoena the head of the prison of the Kokstad.
Why?
To confirm what happened while I was there for 2 months regarding to my requests and complaints for the consultation with my lawyers.
I'm not going to call him for that. I'm not going to allow you to call him for that.
So basically, is it correct if I say that I wasn't allowed? Is a fact. Because that's the fact.
We've dealt with these issues. I'm not going back there.
And can I call the head of the prison from Zonderwater?
No, not unless there's a reason why he's relevant to the sentence which I'm required in due course to impose upon you.
Can I have the
So what is he
attendance
going to
for
say?
my lawyer, my lord?
Your lawyer?
Yes.
Why do you want to call your lawyer?
Well, I told you from the start that I want my lawyer to represent me, and I am entitled to have the lawyer, and I wish to try to arrange the lawyer for tomorrow. Because
You mean to phone him?
to phone him, yes,
Not to call him as a witness?
No, to phone him.
Well, phone him, see what you can do.
So, is it possible that you can give the court order that
No,
I
I'm
will
not giving any orders, Mr. Krejcir.
Okay, my lord. That I will try my best, like you said.
Yes. Make sure you succeed, because tomorrow there's
My lord,
unlikely to be
it's
any
not in my
stay.
hands, you know. If I go back to prison and they will tell me you're not calling, that I will be
Mr.
not.
Krejcir,
Yes, my lord.
I've no intention of arguing with you.
Well, it's not arguing; it's just fact.
It's a fact that
Yeah.
you will do what you can. Tomorrow you will tell me, and you make sure that they come. I don't know why they're not here. You may not have paid them. I don't know. I just don't know. I'm not getting involved.
This is
in it.
another allegation about the money. It's not
I'm
the
not
issue
saying.
that I
I'm saying to you,
disobeyed.
Mr. Krejcir,
Yes, my lord.
don't disregard me when I talk to you.
No, I never.
The
With
reason,
greatest of
the
respect,
reason
my
that
lord.
I raised the money is simply to explain to you one of the reasons that witnesses don't come might be because they don't have money. I'm not going to make an order for someone who hasn't been paid to come here. Make your own arrangements.
Yeah, I
Right.
need to have the access to the call, to the phone, my lord.
So I'm sure you'll get it.
Okay, that's fine. I'm satisfied. Thank you.
So I will stand your matter down.
Thank you.
Sven de Neefe.
My lord, the only evidence we intend to present are in the form of 2 reports. The one is a pre-sentence report and the other one is a suitability report.
Good, okay.
Grade consideration.
And what's the position of them?
My understanding, I couldn't attend the pre-trial, is that my learned friend has no objection that these reports go into the record as is. Maybe you can just confirm.
What's the position of the reports which council proposes to hand up?
Indeed, my lord, there's no.
I want to know from you, are they agreed as to fact and opinion? Or are they agreed as to fact, or are they agreed as to opinion, or what are they agreed as to? Don't look at Ms. Van den Heeff, it's your problem.
Apologies, my lord, I thought the court is posing the.
No, I'm posing it to you. Are they agreed as to both fact
Indeed,
and
my lord.
opinion?
Indeed, my lord.
Right, thank you.
May I please put, Lord, do I need to read the content thereof
No.
into the record?
No.
Lord, the first one is then a report. It's marked
So
as
I'd receive it as an exhibit. What should I receive it as? SP1, Sentence Proceedings 1.
1, indeed.
So I'll receive them as Sentence Proceedings 1 and Sentence Proceedings 2.
Lord, I just wish to
What's the date?
identify them properly for the record. It is dated 17 November 2015.
Yeah.
It
And the
is
other one?
marked.
That's going to be 1.
Yes, it's
The other
marked a
one?
pre-sentence report, Desai Lepondu.
Whatever it's marked, doesn't matter. Date 1711. Second one?
The second one is dated the very same day. That's
Oh,
why
that's
I would
why.
like to distinguish them, my Lord,
Okay.
as the court pleases.
Right.
This one is marked
So this
suitable.
is pre-sentence report. Pre-sentence report. So if the witnesses come to court, you don't need that witness.
The witnesses
these.
are present in court and they may then be excused by your lordship. Is that what you want to ask?
I'm asking you that. Mr.
Indeed.
Spanenberg,
Likewise, my lord.
yes, Mr. Mashiane.
Indeed, my lord.
Right.
The second
So
one,
if the witnesses, who are they?
my lord, may I just continue quickly and place the second one on the record so that your lordship can mark this one too.
Yes.
It's again dated 17 November 2015. It is marked on the top as a suitability report, consideration of correctional supervision as a sentence.
Okay.
I request that this one then be marked.
Who are the witnesses?
And the witnesses are, the first one is Miss Sakoba,
Yeah.
and the second one is Mr. Mapitsa.
Mapitsa, Sekoba. Oh, Mrs. Sekoba and Mapitsa in court?
Napisa Sikova?
Yes. It appears that the contents of your reports has been agreed by the state and the council and accused number 2, and that neither of them wishes for you to be present in court to give evidence, because the facts that you have set out and the opinions which you have made are common cause between the state and the accused. Do you understand that? This happened during the course of a pre-trial conference which I requested the parties to hold. So it's unfortunate that you were required to come today. So you may be excused from further attendance. Thank you for coming. Right. Yes, Ms. Van den
My
Heever.
Lord, that should be the only evidence
Okay. So
that
then,
will be presented.
Right.
I've got nothing further.
what do you want
at
to
this
argue?
point. I will only argue once all the reports and documents
Evidence
have
is
been
received.
and I will at that point address your lordship fully as the court pleases.
Well, I don't know if I'm going to agree to that, but I'll let it go for now. Yes? Mr. Spannenberg, do you want to have you also got reports?
Yes, my lord, there are 9 reports as far as if it's applicable, as far as accused 3 to 6 are concerned.
3, 4, 5.
It's a pre-sentence report pertaining to each of them.
What's the status of all of these 9 documents?
It is exactly the same. We are at item concerning the opinion
And the
those
facts.
reports and the facts contained.
And what are they going to be? SP 3, 4, 5, 6, 7, 8, 9, 6, 7, 10, and 11. They'll be up to 11, is that right? 3, 1 and 2. What's 2 plus 9 is 11, so it's up to 11.
Well, it's
It'll be
yes,
SP.
yes, my lord, indeed, I follow you.
Right.
And there's also then 4 suitability reports
Also.
also.
So that'll be 12,
15 up to 15.
13, 14, 15. And what's the position of those?
The same position.
Facts and opinions are
Facts and
agreed.
opinions are, we in the state are at item concerning that.
Okay.
Then the last report is known as a victim impact report,
Victim impact report. 16.
16, my lord.
Yeah.
And the facts and opinions there are also.
Who's the victim?
Must look at it.
What about the... Yeah, yes, look at it, right. Okay, so can they all come in?
They can come in. My lord, my learned friend, I asked him for the originals, but I'm
Well, it
afraid
doesn't matter. Well, it's not the old days when you had to make a copy manually
mine
and
are
you could make a
unfortunately-
mistake.
Mine are lost, my lord.
Yours are glossed. Mr. Mashiani, do you have
So are the ones
originals?
he gave me.
Do you have some copies that I can use?
Yes, my lord. I did keep them.
And just for the purpose of the record, do you agree that the facts and opinions in each of SP3 upturned, including SP16, are agreed as turned correct?
Well, not the numbering, my lord. My number seems to be different from.
Okay, well, let's not worry about the numbering, but the facts contained in the
Yes.
documents and the opinions in the documents, you agree?
That is agreed.
Right, so can I have those documents then, please?
Hence, my earlier submission that the numbering is somewhat different. For instance, my lord, the pre-sentence reports.
Mr. Mashiani, why can't you just agree with Mr. Spannenberg what the numbers are? I've got numbers and no documents. So if you give me documents that match my numbering, I'm happy.
It's not going to match the numbering.
Well, you'll make it match the numbering.
Lord, I think maybe, with the greatest of respect, I think what Mr. Mashiani is trying to say is that your lordship numbered the first group
I'm
up to
sure he's
16.
quite capable
It's-
of speaking for himself, this funny
As the
little
court pleases,
Let
my
him
lord.
speak. Okay. So that's mechanical. Then what are you going to do when they're up?
My lord, I wish to address you, but I take it Ms. Van der Heever wants to address you first.
Well, I'm not sure she does. She's telling me that she doesn't want to address me until accused one has done whatever he wants to do. I see he's standing. I don't know why. Please
My
sit
lord-
down,
Lord-
Mr. Krejcir. Please sit down.
Lord, I can address you. I've drafted short.
You don't have a problem with addressing me now.
I have done it.
Right, so before this happens, let me just find out what's happening in this court, because everyone's doing different things.
As a court pleases.
Right.
My Lord, I just handed over the pre-sentence reports. They are 5 in number, so they'll go from SP3 up to SP8. And I placed them accordingly in respect of the number of the accused before this court.
I'm short one. Three, 4, 5, 6, 7. I'll go up to 7.
Yes, ma'am. Now
But you said 8. Did I not hear you properly?
it's the,
Anyway, it doesn't matter. Up to
it's
7.
the 4 pre-sentence reports plus the victim impact, so there should be 5, ma'am.
I've got 5 up to 7.
Yes. Yes, they should run up to 7 months. Indeed. My apologies. Now, my Lord, I've got again the suitability reports. They are 4 in number. So that should take us up to SP11, not up to SP16.
Why are those reports not per accused all put together? In other words, all the stuff for accused 2 is together, all the stuff for accused 3 is together, and so on down until 6.
I do understand that, my Lord. There shouldn't be any problem in putting them
Well, I
in
don't
that
know.
manner.
I can't believe that I'm sitting in court debating what numbers to give to documents.
No. It's not.
You write whatever numbers you want on them.
Yes.
I'll deal with them.
Those are all the reports, my Lord. Hence my earlier submission that the numbering will be different from what the court had earlier said.
This stuff goes to 11, Mr. Spanenberg.
Indeed.
So I'm short a whole lot of extra things according to you.
You short documentation. Well,
I've
there's
got-
9 for accused 3 to 6 below. There are
Okay,
9.
let's have a look. 1, 2, 3, 4, 5. Right, so I've got 5, and I've got another 4. So I've got 9.
So, and then there must be then the 2 for accused number 2.
And I've got the 2 for
So
accused
there are
2.
11 more.
But previously we went up to 16.
Yes, that doesn't add up a lot now.
Look, I'm just the judge over here, but can't we get this fixed up?
I picked you up at number 11, my lord, I think, and then added. But it doesn't matter.
Mr. Mashiani, are all the documents referred to by counsel up to SP16, the victim impact report, contained in this set of bundles that you've given me?
Up to SP11.
Yeah, but he's had 16 of them. So are all the things that he numbered up to 16 here?
Yes.
Right,
And
so,
according to me, they number up to 11.
and it's everything.
It's everything.
Okay, well, I'll give you a chance to check that it's everything, and if it's not, you'll hand it up. Okay, now let's just come back to where we were. So I'll deal with you in a minute. Right, Mr. Krejcir, you stood up. Did you want to say something?
I will ask you, my lord, I'm regarding these
just
chains,
wait,
I
just
am
wait.
on these chains for more than 5 hours and
Krejcir.
my numb and my hands and feet
Yes.
are numb.
Yes.
I have the pain. Is
Did
it
you speak to
anything-
the security about whether you can be released from them safely and whether it's a security hazard if you are released?
Which guy from security, my
I
lord?
don't know.
Because last time when I came here, it wasn't anything like this, so it's the first time.
Well,
so.
I don't know. The issues of security are no longer in my control. So the security, if the security says you have to wear them, you have to wear them. Right.
Thank you.
Ms. Vandenhoef, why don't you want to carry on and argue whatever you have to
My
argue?
Lord, because normally the way the sentence works is that all the evidence are presented, and only after evidence is presented by the accused and by the state, then the court is addressed, taking all the evidence into account.
Yes.
And I propose that's the way that, with the greatest of respect,
Well,
Your
why
Lord.
can't, what prejudice do you suffer if we carry
My Lord,
on?
I'm not going to address the court at this point on it. I would like to hear all the evidence that's presented before I address Your Lordship at the end of the evidence pertaining to sentence. As the court
As I understand the law, you're entitled to address me at the end of the evidence relating to your accused?
My lord, that's not the way I understand it.
Well, I want to know
It's-
what the law is. I'm asking you, what is the law?
The
You
law-
wanted to, Ms. van den Heever, you wanted to argue this point. You knew it was going to come, so where's your authority and where's your assistance to the court to enable it to decide this issue?
Then I'm going to ask the matter to stand down. My lord, I've never ever, when I've addressed the court in sentence,
Does it
had
mean
to
it's
deal
right?
with it in a different way.
Well-
So I didn't even think of it to bring the court authority.
You were
on the-
asked.
My lord,
You were
may I
told
please-
previously.
May I please finish, my lord? I didn't even think that it would be necessary to address the court on something that happens almost on a daily basis in our courts in this manner. So if your lordship wants me to address you with authority, I can endeavour to go and find the authority.
Why didn't you do it before? That's
Because
my
I didn't
question.
think it's going to be an issue, my lord.
You knew it's an issue.
No, I didn't know it was an issue, my lord.
Before I asked all counsel whether there's going to be interposition, can they deal with this, what's happening, and you didn't bother to prepare and bring authority. So now, I say to you a simple question. Accused one wants to stand a part of his case down and run it tomorrow. Why is it not convenient to you to deal with the entirety of accused two's case now?
My lord, because again, as I've indicated to your lordship before, in every manner that I've ever been involved in where sentencing has happened, the manner in which it happens when there's multiple accused are that all the accused present their evidence. Then the state present their evidence. And only after all the evidence, whether it's documentary, viva voce or otherwise has been presented, the court is then addressed in turn by the various accused.
Ms.
And I'm
van den Heever.
asking the court that is the process that we follow here.
Ms. van den Heever, I asked you a question.
I've addressed your lordship on it.
No, you haven't.
I have.
What prejudice do you suffer if what is the usual course is not followed?
My lord, I submit it's not the usual course the way your lordship wants to proceed.
I said to you, assume that the usual course is not followed, i.e. we don't do what you believe to be the usual course. What prejudice do you suffer?
Until such time as I've heard the evidence being presented by accused number 2 or by accused number 1, my lord, I cannot address your lordship on potential prejudice. I need to hear what evidence he presents and then I can address your lordship on that point. Your lordship has not asked Mr. Mashiani for the state whether he intends to present evidence. I cannot address your lordship in the absence of him dealing with the issue of whether he foresees that there's going to, or whether he wants to present any evidence, as the court pleases.
True. You're ready, willing, and able.
I am, Lord. In fact,
Let me just hear from the state whether there's more evidence. Ms. van den Heever
we dealt
raised
with that at the pre-trial, but yes.
Well, I understood it to be so, but it's not something which has been made public. Perhaps Ms. van den Heever, who declined to attend the pre-trial, doesn't know. What is the position as far as the state leading additional evidence is concerned?
Well, the state is not going to lead to any evidence, I'll argue.
Can you suggest what prejudice accused 2 might suffer if he is required to carry on with his case now?
None, my lord. I submit it.
Right, what's the time? Well, we'll start with you, Mr. Spellenberg, and then we'll go to possibly to accused 2. We'll see how far we go.
As a court, please. I've drafted brief heads of argument.
Accused 3, 4, 5, 6 heads. Thank you. I'm grateful to you for preparing some heads.
Simple, please. Lord, the personal particulars are at length before your lordship, so I won't deal with that.
Yeah,
That's
no,
all
well,
part of the reports.
yeah.
I submit.
Perhaps you can just help
my
me
perfect understanding.
by indexing these reports.
I just indicate I don't have a copy of the dates.
Sorry.
I'll be reflecting.
Right, okay, so in SP3, is Mr. Maruping.
Indeed, my lord.
Right. Right. So you say that I must look to this report by page and number, and then I will see what?
No, I'm not. I haven't referred to the reports, my lord.
No, no.
They're there for the.
But I must add on what you say in the head.
Yes, I intend addressing your lordship on the merits of the case, of the different offences for sentencing purposes.
Yes. And the facts underlying each of those
Yes, my lord.
submissions I'll find in each of these reports. Okay. Yes, we can do that.
Yes.
Right, so let me hear the argument which you have to make in respect of 3 to 6 inclusive.
As it would be.
Right, per your heads.
My lord, perhaps we should just to remind ourselves, if I may just say, what the accused were convicted of.
Yes, I'm grateful to that. I need that
been a
as
while
a starting point. So 3 is kidnapping and attempted murder, 4 kidnapping and assault, 5 kidnapping, attempted murder and attempting to deal, and 6 kidnapping and attempted murder. Okay?
Indeed, sir.
Right.
Now, I deal with it in the headings of the different offences.
Correct.
First heading is kidnapping and assault.
Okay.
My first submission is that there's no evidence, I believe it wasn't your lordship's finding, if I'm correct, that 3, 5 and 6 were present the night when Lukele was kidnapped from his home.
Right.
There's no evidence. In fact, the only evidence is that of Lukele, who pointed out accused number 4 as
Yeah.
being present there.
Yeah.
My submission as far as the assault is concerned, of which accused number 4 was convicted, and that relates to the incident at Lukele's house. I submit that that assault
It's part of the kidnapping.
is part of the kidnapping. It was a process.
So that's a question of concurrency.
That's my submission, that your lordship takes those two sentences of offences together for purposes.
Was he convicted separately of the assault at the house?
He was, yes, my lord.
So 4, it's the assault at the house,
Yes.
not anywhere else, and the kidnapping.
And the
And
kidnapping.
you say there's concurrency.
That's, yes, part and parcel.
Okay.
There's also, and I submit this to me is quite important, there's no evidence that accused 3, 4 and 6 were at any stage present at the safe house.
So that's duration.
Yes.
Duration of kidnapping.
Or any evidence that they even knew about the safe house.
Right. Well, that's the same issue. It's duration.
Yes, my lord.
I mean, was he kidnapped for short term?
Yes, indeed, sir. Then, as I understand, with respect to your lordship's judgment on the merits correctly, you found kidnapping to have been perpetrated during the trip to Ermelo, and that's
Yeah.
where accused 3 and 6 were on that. They were convicted on the basis that they were involved in the kidnapping on that trip.
Yeah. So that's a Soki.
My submission is that they were not, there's no evidence that they were directly involved in restraining or containing or keeping Lukele a prisoner on this trip. He was in a different vehicle.
So it's got to do with the extent of control over the
Yes.
kidnappee and the extent of the fear and consequent
Correct,
conduct.
Lord. As I understand your lordship's...
It's an extent issue.
yes.
So how severe is the kidnapping if I'm not directly doing
Not
these
directly.
things?
Your lordship's finding, as I gather, that they knew about it, but they were not directly involved in the restraining.
They weren't holding him down or
No.
blindfolding him or pushing him to the bottom of the car or doing whatever
Correct.
was done. Right, I
So-
understand that.
Yes.
So you say that's a less moral blameworthy position.
Indeed, sir. As far as the attempted murder is concerned, my lord, I submit that it would appear that accused number 1, and looking at the evidence, that he was on a frolic of his own when he poured the boiling water over Lukele.
Yeah. You say they didn't do it. At best they're Soki and they couldn't do much to dissociate themselves from the act because it happened fast. Is that your submission?
Yes, my lord, it seems like a spur of the moment thought by accused number 1. One looks at Lukele's evidence.
Well, he seems to know because he did some things. He did the look at me, do you want to die like a soldier move. He did some of these things.
Yes, indeed. But then he went to fetch the boiling water and they poured it.
Well, he went and boiled the kettle and
Yes.
brought back the kettle full of boiling
Well, there's no
water.
indication that...
Well, he must have, it wasn't where they
what
were.
I'm saying is that the accused 3,
Were-
5 and 6...
they're not active
Not
participants.
Yes. As I state in my head,
Okay.
at most they passively reconcile themselves accused one's
Right.
actions.
Okay.
And looking at the injuries, that be so. The assault with boiling water must be horrendous. But looking at the injuries, my lord, I submit that the injuries weren't life-threatening.
Well, he managed to recover.
He managed to recover. He didn't need.
I think he's recovered completely, except
so.
for some skin pigmentation.
Look, even it seems to me, my lord, in terms of the evidence that he delayed the treatment after his release as well. It wasn't as if he went for emergency treatment immediately.
Well, he'd been treated by one of the accused who gave him some help on the way, didn't he?
Yes, but my lord, that's treatment by a layman. But the fact of the matter is,
He did go to the doctor
did
the
go to
next
doctor,
day.
but it wasn't life-threatening. He wasn't hospitalized.
Well, he recovered.
And it seems he was never at
The
any stage-
sequelae, I think the point you make, the sequelae are not
Yes,
the sequelae are not substantial. Right.
and as far as accused number 5 is concerned, I think, Lord, you make a very important finding that he was opposed to killing.
That's a subsequent killing, of course.
Yes, but it does affect really his intention, or the extent of his intention at the time of the occurrence of the assault.
Yeah.
It does. I submit it does reflect on his criminality as far as that offence.
Yeah.
My Lord, then my
Dealing
last
with
submission is that Your Lordship not only takes the time accused 3, 4, and 6 were held in custody pending today's sentencing, which is 6 months close to, but also taken consideration that they were in custody for 6 weeks after their arrest before they got bail. But that Your Lordship, in fact, considers this when imposing a sentence. It considers as to regard this as a possible double the period. And I refer to a matter, the matter of State versus Stephen, where His
The
Lordship...
double period's been done away with in the SCA.
that period.
It's now to be regarded as a factor.
Yes, my Lord.
I remember historically we used to give double off. If you were in for 6 months, you got double off.
Yes, but I do, that matter, it was said it may be regarded as double the sentence. But the
I've
fact
forgotten the
that
name
is,
of the case, but it Brophy,
yes,
State versus Brophy.
yes.
I think it's been not overruled,
No,
but
no,
it's
but
been modified.
it's still a consideration, simply for the fact that the circumstances of your incarceration as a waiting type trial prisoner.
Well, they're actually better, I think, than...
No, my Lord, they don't
they're
have the
not.
same privileges.
Do they get... Is it worse?
It's worse.
Okay.
It's worse.
I
That's
thought
what,
I
that
thought
was the ratio
Of Brophy.
No, of Stephen.
I thought that one of the reasons was that if you get a year, then you get half off roughly
Yes.
by the parole board.
Yes.
And so if you did 6 months, it actually counts for a year.
Well,
I thought that was part of the thinking.
I don't think Your Lordship can really...
And I think that thinking has been done away with,
Yes,
that it's
yes.
not good.
Indeed, so. But my submission is that it must be
Well, I must
seriously
take it
considered.
into account in some way.
Seriously considered as a severe form of punishment already.
Well, it's a factor.
It is a factor in terms of Brophy, yes.
Okay, what do you say about this dealing in, or attempted dealing in the drugs?
Oh, I haven't dealt with that, have I?
Well, you
accused-
missed 10 and 11 for 5.
Accused 5. I must admit that he was very peripheral to all of this. The only evidence really which incriminates him is his own ipsa dixit, where he says, I think it was Peter who testified to this, we are seeking drugs worth millions. But he's really peripheral, my Lord. He acts on, everyone looks at what happened, he was acting on instructions.
Let's just
He
look
wasn't
at them.
involved in, doesn't seem that he was involved in the actual pre-kidnapping or pre-doctor scenario drug dealing. And I think that's important. There's no indication in that.
No,
There's,
it seems to be in 1 and 2.
yes, my Lord, it seems so. It seems so. And that's my submission as far as accused 5 is concerned. He peripherally was brought in
But no,
Not
let's
to
just
deal
deal
in
with.
drugs.
Let's
as
just
per
deal
se.
with what they are. So what is 3? Is he a policeman?
3 is a policeman, yes.
We're holding what rank?
Warrant officer. They're all 3 warrant officers, 3,
3, 4, and 6.
3, 4, and 6.
4 and 6. Policeman. The warrant officer. Policeman. Warrant officer. And 5 is a taxi person.
He's a taxi owner and taxi business.
So if we look at 3, 4, and 6 who are policemen, what's the position in society when officials you appoint to combat crime, as it were, betray you and go to the other side? What attitude should society adopt to that?
Well, case law is adopted the attitude, my lord. It is, and I'm sure my learned friend will argue that more strenuously than I do, but no, it is aggravating, no doubt.
And then I wanted to ask about the drugs, the same question that I asked accused number 1. If there's 25,000 grams or 25 kilograms of drugs, let's call it ice or meth, crystal meth, then how many, I don't know, I think the colloquial word is a hit,
Yes,
or whatever, I don't know if you suck it up your nose or you shoot it into your toe or whatever you do with it, or you eat it, I don't know what you do with
well,
it.
I call it eating with your nose, I believe.
They call it eating with your nose. So how much of that do you use? Or do you have a submission
No, my
as
lord,
to how many people or how many hits, to use that way, translated into people, that quantity of drugs would produce? Would it be 25,000 people? Would it be 50,000 people?
My lord,
I know that
should-
when you take drugs, they talk about like 250 milligrams or whatever.
Yes.
And this is a heavy dose for you. Now, I don't know, is it like that with drugs?
Well, I suppose
Do you have
some people take singles, some people take doubles, my lord. As with alcohol, I would not know, my lord.
You don't know.
I would not know.
But I mean, they wouldn't take more than a gram at a time, would they?
Gram seems
It
to
seems
be
quite a lot.
quite a lot.
So let's say they're 25,000 grams. And that's 25,000 people.
Well,
Let's say each person takes a
number
hit.
of users, yes, my lord.
So now, if you take 25,000 grams and 25,000 people, if they take one a day, then how many, that would be 25,000 people. But if it was one person, how many years supply is there? There's a few years, a 50 or 60 years supply. I don't have the maths. But one can do the sum, it's a long time.
Look, it must be, if one looks at the value,
Or the number of people.
yes.
So if I translate that into, say, a day, a person, that'd be like minimum 50, 60 years.
Yes.
What,
Well, it seems
what
a lot,
is
but
the...
I'm not.
No, I know.
I'm in the dark.
I don't know. Yeah, so you don't have a submission to make.
I have no solution.
It just
My
seemed to me
submission
that if someone did the sum, so 25,000 people divided by, let's say, 500 days in a year, would be 50 years. If I give the accused 1 day for
Well,
each of
Yes,
those,
depends on the frequency.
for each of those uses, he would have to get 50 years.
I can imagine that
And if it's less, then he has to
25.
get proportionately more.
25 kilos must be a substantial supplier, no doubt.
And then the other question is this: do we owe the Australians that this was going to some kind of duty to protect them from our criminals by imposing punishments which are appropriate to prevent and deter our criminals from conducting themselves as a threat towards Australians?
Well, there can be no doubt about that.
So I must take society as including the extended society, which would include, let's say, the intended destination of the drugs. I must consider that we need to protect these people too.
I don't believe there's room for to differentiate between victims, the nationality, for instance. I don't think so. No, that
So
can't
it would
be.
be appropriate to say society includes the destination for which the drugs
I
are
would think
intended.
so. But may I just add, as far as accused number five is concerned, Lord,
5, yeah.
he was, as I say, on the peripherals. He was not the supplier. He was only the searcher in this case. As
He
you-
was a protector of the persons who were doing it.
Yes,
That's really what he
But
was.
the fact of the matter is, there's no indication that dealing in drugs was his business.
Now his drugs
He was brought into this as part, as management control, I should think.
Yes,
for the
like
lack
a
of better
protector
word.
of the business.
Yes, my lord.
Isn't that just as bad?
No, my lord, he was brought in at the stage when it was, he was never needed, as I understand the evidence, there's no evidence to the effect, never needed an actual drug dealing.
No,
He was brought
there's no
in,
evidence that he actually...
He was brought in, things have gone wrong, help us.
Yes, protect my business.
Yes, and that's much different than your normal. I know the definition for dealing in drugs is very wide. It's got a whole list of.
Yes,
We know that.
associate with...
Oh yes, my lord. If one looks at that definition, there's actually no room for possession. In actual fact, because if you possess,
Whatever you do, you're on.
you're on. So wide is the definition. We've argued that point a number of times. Possession also involves dealing. But be that as it may, he was, as I say, not a mainline drug dealer. He was brought in for management, control, risk management, whatever. He's not a seller. And I think the seller is, the definition may be wide, but I think the seller is the main target in any such drug-related deals. He's the main target. He's the main perpetrator. He was on the side.
I seem to recollect that I gave a mule, or I was involved in giving a mule who had 5 or 6 or 7 kilograms, some less than 10, about 17 or 18 years. I haven't found the case, but I think I had something to do with it. That I gave a mule, in other words, not the actual perpetrator, someone who just needed money and either somehow conveyed the drugs from A to B. Cross-border control.
But
And I think that was 17 years.
we're talking about actual possession. Here we're
Actual
not
possession.
talking about that.
Yes.
There are fine lines, my lord, but he's not a carrier. He wasn't a carrier. All he wanted was information to
His enforcement.
Yes, pass it on, enforcement. But whether he was, well, there's no indication that he was going to deal in any way.
Yes. So you say his moral blameworthiness is
Yes.
less than the moral blameworthiness of the actual perpetrator.
I submit so, yes.
So what I wanted to ask you just about drug business in general, I don't know if you can make some submissions on it. If you go to some lawful type of business, I don't know, to take a supermarket like Woolworths or Macro or whatever, these people, they sell their product. And you could choose how much you want to pay, if you want to buy. If you don't like that supplier, you go somewhere else. Now, is it the same with drugs? Or is the position a bit different on the part of the buyer? Isn't he kind of compelled because of his dependency to buy, and then he's kind of compelled to pay whatever the price is? And because there are not so many of them, you're compelled to deal with a particular person. And so now the whole business proliferates. You find people who are prepared to pay any price, as opposed to a normal business where you can choose your customer. I know you see among the richest men in the world,
Yes.
you see drug dealers.
Yes.
It might be a reason, I don't know. I'm trying to get to grips with how you treat that. Is it different? Yeah.
Lord, I would like to say that the price, you can ask any price, and you'll fetch your price. But I think, unfortunately, the drug market is so big that there is competition. It's not just a matter.
There's some cutoff.
There's a cutoff. I think.
But you can't choose not to buy as the user.
Well, you
I mean,
can't
you go
choose
to
not
the-
to buy bread and milk, my lord. I mean, it's much the same. Yes.
Bread or milk at the price of a TV set.
Yes. But I don't think that happens in
I don't know.
in the
These
market.
things are just.
I think there's
but
competition. You
I'm
can go
worried
to,
about it.
You can go to various dealers and bargain a cheaper price, I should think.
Mm.
There are dealers, if you walk down Long Street in Cape Town,
The dealers in anything.
you can walk down And you can negotiate a price as you go down and go back to your best offer further up the street. That happens. I'm sure that happens in all types of drugs.
Yeah. Thank you.
Thank you.
Then what else do you want to say?
Those are my submissions. Well, my final submission, which I didn't come to, there are the reports from the probation officer,
Yeah.
the suitability report.
Then what do you say
three-
is the right way to deal with these people?
3, 4, and 6
3, 4,
have been
6.
found to be suitable for correctional supervision.
Super correctional supervision.
If you look at the reports are not before you, but your lordship doesn't have knowledge of the content, but you'll see that from.
So what does that mean? They've got to get. There's a cutoff on in the section.
There are
to
two
get-
sections,
Yeah.
276I and 276H.
Yes.
Uh,
Okay. So now
H is the one where there's
276I,
immediate house arrest.
276. That's me making an order.
Yes.
Yes. You will not go to jail. You will serve house arrest, and that's got a cutoff point.
That's H.
More than how many years?
Not more than 5.
Yeah. So it's less than 5 years.
5 or less. Yes.
So I've got to decide firstly, before I can apply H, that an appropriate punishment is less than 5 years.
Yes, 5 or less. Yes.
If I want to make an order under is it? Yeah, it's H.
Yes.
And under I,
It's within discretion of the prison correctional supervision authorities
also dependent upon a maximum
of
punishment
5.
of 5.
And the policy is it's not enacted as far as I know. But the policy is that at least a 6. That's the terms of the regulations. At least a 6 of the sentence must be served in prison. So for 5 years, that'll be 12 months. Yes.
The point is that to trigger these two sections, the first thing I have to decide is that the punishment is less than 5 years. 5 or less.
Indeed, sir. Yes.
If I think it's 5 or more, these sections are gone.
Yes. Because there's the authority, I haven't added it, that correctional supervision, I think it's quite
Well,
fine.
that's
It's not a lesser sentence.
but that's correctional. No, that I agree with you. It's not a lesser sentence.
I know
No,
that's
it's a
right.
punishment.
It's a punishment. It's not less. Because you do 5 years correctional supervision under H, doesn't mean it's a lesser sentence than direct imprisonment of 5 years.
Yes.
The only question is, according to authorities, is it suitable?
And I think I wrote a judgment saying that imprisonment in the section includes these forms of imprisonment.
Yes.
So if I'm with you that it's less than 5 years each, then I can do that.
And if your lordship looks at the reports, they are highly suitable. They are well rooted. Family men, children, own homes. They are well suited for correctional
Well,
supervision.
the issue is whether the deterrent effect of punishment is met
Yes.
by them serving only 5 years.
But Lord must, with respect, take in consideration the 6.5 or 7 months plus they've already been in prison. So your lordship was looking at closer to 6 years, whether that's appropriate, if I may make the suggestion, because the term spent with respect must come into consideration. So your lordship was actually looking at a longer term of
So
imprisonment.
I've got to say, if I take the pre-term punishment into account,
Yes, looking at
then it must
an
be more.
appropriate longer term.
Yeah. Okay.
And if your lordship thinks 6 years was the appropriate sentence, it is still going to be as such applicable to a 5 years correctional supervision,
Yeah.
considering time spent. Well, Lord, and it's also from the reports. Look at the police officers. They have
They
clean-
seem superficially.
clean records, my Lord, up to these.
Well, that other record's irrelevant. I'm not taking it.
Well, that's
into
accused
account.
5.
Well, forget about
Yeah,
that.
I know you. Yes, my Lord. That's old records.
Completely ignore that.
Thank you, Lord.
I think the state agrees. That's why they said they don't care if he doesn't admit the one
it's,
missing one.
it's old and not really applicable.
It's not really relevant. It seems to have been some trifling offence.
Yes.
The thing that concerns me is whether policemen who do this kind of thing,
But-
or who are should be treated this way. I know policemen are vulnerable because they get paid perhaps salaries which to them seem insufficient.
Well, Lord,
I don't want to
important
cast a
aspect-
moral judgment on
Yes.
whether it is insufficient or not, but
But having said
I
that,
know that there is a sentiment, am I allowed to take this into account, that there is a sentiment amongst the police that they are ill paid, if I can put it that way, for the work they do. So the temptation is what I'm putting to you.
yeah.
Must be great. If you don't protect the protectors, then the temptation comes. Yeah, I don't know. I've got to balance that issue. Can I do that? Can I, without evidence? Can I say, well, there's a temptation, they
Well, I think your
humbly
lordship can
paid
take
people.
cognizance of that. I mean, it's, we know the circumstances, we know the conditions and the salaries, what they earn. We know that. The danger is to overemphasize that they're policemen. It's a real danger. You are the upholders of law and order. Indeed, so it is aggravating, but it shouldn't be done in isolation.
But I'm equally the face of society. So society's face must be seen.
Yes, my lord. Yes, but in any offence, there's that sort of aggravation.
Yeah.
A company director, employer, employee. It's much the same. It must. One looks at positions of trust, of course, but don't, with respect, my lord, don't destroy lives that can be salvaged. That's the issue. Are they open to be rehabilitated? I submit they are. So they are all three. The policemen are middle-aged men, my lord, with school-going children, and that's the further aspect, my lord. They all support children. And reports are unanimous as far as all three of them are concerned. They are good fathers.
There's a very new case on that. I think it came out yesterday or the day before,
I haven't read.
where a woman who'd committed a significant fraud was given I think a 3 or 4 year correctional service type
Well, there's the-
sentence
There's
for
the-
several million rand.
There's a matter of the two policemen who got also for fraud, and one of the aspects the court took into
This was exactly on point of children.
yes, we don't. Does society want to be burdened with the children of convicted persons? Sometimes inevitable, but it must be limited, my lord, with respect. The children is a very, very, you'll see from the reports. my
Well,
lord.
they're entitled to parents.
They are indeed. And these parents are caring, these accused.
They're good to their families.
They are.
They are.
They are present. They are
They're proper in every way except that they committed this act.
indeed, sir, my lord. And that's.
That's what makes it
It may be construed, my lord, between the lines that they did this for their children.
No. The temptation.
Yes.
That's why I talk about temptation.
Yes.
Okay.
So
So then you say that.
it will destroy family lives. Now this is an old story, and it's been bandied about a lot. But this instance, I submit that if you have any hope for them, my lord, I urge you with respect not to destroy them and their families, because it goes hand in hand.
Their sets of facts are different from the facts of 1 and 2.
Yes, my lord.
So now, Ms. Finnenheffer, is that what we want to really say on sentence?
Yes.
So Ms. Finnenheffer raises a technical issue. So she says she has a right to hear the evidence of all, including one, before she presents her argument. So now, if there was a separation of your accused, I don't know what her position is as far as your accused is concerned, but assume that your accused are dealt with summarily today.
Yes.
Would that be wrong?
No.
Do I have
Section
to make a proper separation of the hearings?
Well, Section 157 says at any stage trials may be separated.
And would that be an appropriate point or reason to separate them?
Well, at sentencing stage is the safest stage, because the approach is there any prejudice?
Well, I kept asking Ms. van den Heever,
And
but she declined to deal with it.
I submit that really I foresee no prejudice. That's why I have no qualms in addressing you before other evidence, because I don't foresee any evidence being led now at this stage is going to affect accused 326. I don't foresee that. It's not going to affect. I really don't see it. And Mr. Mashiani myself has discussed it. He's not going to lead evidence, so I know what the position is. The state is not going to suffer any prejudice. Separation of trials is where
So would you be happy if they were separated out and we dealt with
I would be.
your 4 accused
If
today?
I'm called to,
And,
I will
I mean,
ask
if it comes
make
to
such
that.
application.
If
Yes,
it
my
comes to that.
Lord. Yes, my Lord. No need. No need. That's my clear instructions, and I think it's good instructions, and I will further that application. Yes.
Well, before that happens, I mean, it's just a speculative thing which I'm putting to you. Perhaps you can think about it over lunchtime. I think we'll take lunch now until 2 o'clock. And then if everyone could just think about that thought. Ms. van den Heever, I would ask you to consider seriously, and to, if you tend persisting in your attitude, see if there's some authority which supports it. In the meantime, think about the position of 3 to 6. Same for you, Mr. Mashiani. Right, so then we'll carry on after lunch. So then the accused should be taken down to the cells, and then I'll adjourn until 2 o'clock. Accused may be seated. Mr. Mashiani.
Is the court. My Lord, just to give an update pertaining to the issue of the interpreter, I have managed to get hold of Ms. Heshmalova, the interpreter that we used on the previous occasion. She indicated that she's only available on Thursday to come and assist this court. She further indicated, my Lord, and I don't want to seem to be contradictory, she indicates she can make herself available tomorrow on certain conditions, i.e. the financial commitments from the Department of Justice. I've now spoken further to Ms. Mukwena. She's apparently the person in charge, and she informs me she's today not at work and had delegated Ms. Zolega to take such decisions. I've tried already on a number of occasions to get hold of Ms. Zolega. I couldn't make it, but I've SMS'd her to give her the update pertaining to this issue of the interpreter. But if all else fails, I've provisionally indicated to Ms. Heshmelova to make herself available on Thursday, being the day that she is normally going to be available. But if I do get any updates from Zolega, I will inform the court accordingly as to the possibility of her being with us tomorrow.
So what I understand from you is that there's no responsible person in the administration of this court who's able to make a decision concerning whether to pay whatever it is that the interpreter requires to be paid tomorrow. Is that the position?
No, my Lord. I'm saying she is not answering her phone.
Well, that means she's not available.
Well, in that regard, yes, I can say. I couldn't get hold of her. I phoned on a number of occasions. Her phones just take me on.
Well, I regard it as a disgrace that there is not proper support by the administrative staff of this court. So I need you to go and deal with that issue. Or I need someone to deal with that issue.
I will see what I can
Immediately.
Immediately, my Lord, I do understand, but I can only deal with that issue as soon as I'm out of court. Yes, the court, please.
Right. Ms. Vandenheffer, can you just deal with your objection to proceeding to interpose your argument at this point?
My Lord,
Assuming that I give you time to deal with whatever additional arguments you may wish to adduce subsequent to the argument of accused number one and his evidence being made public to this court.
My Lord, I've addressed your Lordship to the extent I can. I believe it's undesirable, my Lord, to address your Lordship not having heard all evidence that's presented.
Why can't you address me on matters and then hold in abeyance whatever additional things may, which is doubtful, arise out of accused number one?
Lord, I can, we have prepared draft heads of argument. I wanted to supplement. I can at this point address your Lordship.
Yeah.
As far as I possibly can
Yes.
today with, and then I reserve the right to, of course, deal with further issues
And I'll let you.
tomorrow. And
Subject to unreasonableness, I will let you.
that I have no problem with,
Right, well
my
then
Lord.
let's do that. Subject to what Mr. Mashiani now apparently wants to talk. Yes, Mr. Mashiani.
I see accused number one is constantly raising his hand.
Yeah, well, I'll come to him now. Let
Yes,
me
sir.
just deal with this issue. So you don't have anything to say on this issue?
No, my lord.
Right, okay, that's all. I don't want a long story. Thanks, Ms. Van den. Let me just hear what accused number 1 has to say. Mr. Krejcir, apparently you were standing up. I didn't notice you.
I beg your pardon?
I didn't notice that you'd stood up. It's been drawn to my attention that you may wish to say something to me.
Yes, I would like to.
Yeah.
My lord, I would like to bring the application to remove my chains on base of the judgment State versus Spirit.
I'm not hearing that application now. I'm in the middle of doing something else.
Okay, then.
I'm not hearing your application now. I'm doing something else, Mr. Krejcir.
All right, thank you.
Right. So I'll deal with you, Ms. Van den.
May it please the court. My lord, as with the accused number 3 to 6, the pre-sentence report as well as the suitability report in respect of correctional supervision
Of 1.
deals with 1 and 2 deals quite extensively.
I mean of 2, sorry.
Yeah. Accused number
Apologize.
2 deals extensively with the personal circumstances of the accused.
Okay, so that deals with
Yes.
the first portion of the triad, your personal
Indeed.
circumstances.
And that I will hand up to your lordship
I've got.
tomorrow, a summary of all the personal
Okay,
circumstances.
well I've at least got them in here so I can
Indeed.
understand this. So what does it say? It tells me how old he is and where he went to school and who his family is and that sort of thing.
Indeed.
And
my
what
lord.
he's been doing in society till now and how much money he earns. And in general terms, all about him.
It deals in general terms with him as a person.
Yes.
The content of both these reports, my lord, are not in dispute, both in fact
Yeah, no,
and,
we've got that.
and indeed in law. The second document also recommends accused number 2 for correctional supervision. Your lordship has had the debate with my learned friend acting for accused number 3 to 6 as to the 5 years limitation on whatever kind of sentence.
As I understand
is
it, that's the
imposed.
trigger. If
That
I
is-
don't agree with that, then it can't happen.
Indeed. And there's a number of ways, of course, in which the court can deal with the imposition of a sentence. That is by making sentences run concurrently, by suspending periods of sentence.
So if I give him, let's say, 100 years,
Then
and
this
I
doesn't-
suspend 95 years, then does he get treated as if I gave him 5?
Indeed.
So it's the unsuspended portion which is relevant.
It's the effective period of imprisonment, indeed. That is the relevant
Okay.
portion.
Yeah, where there are multiple counts.
Indeed. Because there's multiple counts.
Okay.
And I will, in due course, and I'm going to ask your lordship's leave that I deal with the specific case law in respect of the various offences tomorrow. As I said, we've set it out for your lordship in draft, and I will make copies available to your lordship
I don't
tomorrow.
think I've got the heads.
What I would like,
Have I got heads from you?
no, my lord, because we assumed that we will only by tomorrow argue to your lordship. I think, if with your lordship's leave, I would like to deal with your lordship's judgment and your lordship's findings at this point.
Okay. So you want to deal with the leg called crime?
I want to deal
The crime.
my lord.
As that the matter urgently stand down, there's a security issue to be attended to immediately.
Got it, Judge. Left, Judge.
All right. There's a bomb threat in this building. There's a bomb threat. In this spot. See you later. So you bring them tomorrow.